What's up, everybody? It's Operation Wisedome. It's Wednesday, July the 23rd of 2025. What's up, everybody? Y'all say hello to everybody out there in the world.
Hello,
Hello,
everybody in
everybody.
the world.
What's up,
Hello.
everybody?
Hello.
Hello,
What's
everyone.
up, everybody?
Yeah, y'all know Operation Wisedome, we deep, so don't get it confused. It ain't just 9 of us, even though 3, 6, 9, 10 on the screen, you got it messed up. There's a lot of us in here at all times. And we're always working to the best of our abilities to help ourselves, to help each other, and to unify this world with great knowledge and wisdom so that we can start to really understand that I am you and we are us and we are all a part of the great I am. This great creation that we are so blessed to be in at this very exact time. This week's been pretty busy, man. It's been stressful for me on many levels, just for my own things that I'm taking care of as far as Hood River is concerned, but then also others. As you know, Sarah's going through a lot right now in relation to her interlocutory appeal, getting immediate denial and going through the same issues that she's having on the lower end. So she's having to do a lot of emergency aspects, move in extraneous ways that we just wasn't projecting through the deep research that we've been doing over the past month now. We really looked at the probability of what would be most successful. And we could have gone different routes and choose the route that we saw would have the highest probability as far as constitutional rights. And it just didn't happen. And what we're seeing is a systematic detriment to our constitutional rights, a systematic fight and just travesty all the way around. And it's unfair. But we've seen that happen over and over throughout time. And we'll actually go through one of those things here soon in just a moment. Because tonight's going to be the first night that we starting up an interlocutory relief series. And tonight's going to be module 1. I'm going to try and do this over 8 weeks and see if we can get it kind of just really deep. I think we'll focus on it just on Wednesdays and leave Saturday open for special guests and then workshops. But this is pretty cool because interlocutory appeals is something that I think, we all need to know a little bit more about. And then just the aspect on how you're approaching it makes a big difference as well. And we're going to kind of go through some of those things. I was supposed to have my depositions today. I did not. They pushed it off on my ass, but they rescheduled and we finally confirmed for Friday. So Friday for the first depositions, we're going to be doing Officer Ron Junt, which was he was like the third officer that showed up and was like, take him to jail. And, he's doing all that riffraff and hollering and, you'll sit there until your warrants come back, boy. And it's like, I don't have any. So like, why would you say that? And so we get to interview him first. That's at 11. And then we'll backdoor with the chief. Didn't really want to depose the chief really, but since all liability does come back on him, I guess I'll just have to hammer him. So that's not a problem with me whatsoever. And then we'll be getting to the rest here shortly. So that's not, get some progress going there. And then we'll be looking for admissions back. Another update for Salem. Troy was able to find something really amazing today while doing some research. I really wasn't going to go towards this approach, and he threw something in, and I was like, damn, that's good, bro. Like, that's gold. That's a really good point there. And so I completely kind of formulated an email today, sent it over to her, letting her, or at least the district attorney, know, I don't think you want to move forward with this because this ain't even really codified in ORS, in the ORS whatsoever. So you might want to look at this a little bit deeper and figure out what's going on because you really can't apply that. If you do, I'm going to come after you. And she got the message, and we went ahead and e-filed today on some information or documents pertaining to that issue. So that's pretty cool. We'll have to go over that at some other point. But yeah, we got in touch with him. Russell, if everybody's not knowing what's going on, Russell had his case dropped on the municipal, and then somehow, somewhere, it got picked up by the district court. And so the district court is now picking up his matter, even though the cop that left or got fired, supposedly in correlation to this matter, even put in a request to dismiss in the interest of justice. We don't know, in the discovery, we don't know if the prosecutor's seen that, he just overlooked it or what, but he's going to be kind of screwed over in that one. I'm not going to say too much on that, but we got some cool stuff coming out of that one. So he's going to be doing some refilings and getting that taken care of course, while a federal suit is still pending right now. So he's got a federal suit that's been filed. And I think that's for like 5.5 million. What else do we have going on this week? Oh, Jacob. I was on the phone with Jacob yesterday, I believe. I called him right at the right time. I don't see how it happened, but he had called me like an hour. I had called him back like an hour later, and like 5 minutes later, while we're on the phone, um, can you turn your mic up a little? Is my mic too low? Jeez, I really got it loud, y'all. Let me see. Maybe it's not selected. Oh, it is selected to the right one. That's weird.
That's
I don't know
better.
what's going
That's
on.
better.
It's fine.
That's better now.
I don't know what's going on, man. Yeah, I got the
Yeah, you
internet.
sound really good now. You're good, man.
Okay. I don't know what happened there. Okay, so Jacob though, he had gotten like the 5 cases. One of them was a felony. We got all of those dismissed right off the bat. No prosecute, right? And then they still got citations. So then he goes to his citation score. He's got 3 different tickets, and he's already got everything. Anyways, he's already got a driver's license. He's already got an insurance. He's got all the stuff, right? But he's still got tickets for that. So that's what was so weird. And so he's showing them, he's like, hey, can I see this? And he's like, yeah. And then he starts talking about the license plate cover. And the judge is all like, do you still have it on there? And he's like, no, I took it off immediately, Your Honor. And I got rid of it. What do you mean you got rid of it? Where'd you put it? I put it in the trash. Oh, yeah? So you can't go back to the trash and get it? Nope. Now, let me ask you this, Jacob. Was it dark? Was it, the judge goes, was it dark? Jacob goes, the license plate was legible, Your Honor. He goes, that's not what I asked you. I asked you if it was dark or was it clear? He said it was legible, Your Honor. The judge gets pissed and he goes, was it clear? And Jacob goes, it was clear. Just like that. It was clear. Yep. And the judge goes, all right, everything's dismissed. Have a good one. So we literally got, because there's no pictures, right, of the license plate cover, right? There's no evidence that's been presented into the municipal court. So, was it clear or not? From my I didn't see it, but from what Jacob was telling me, it was clear. You see what I'm saying? So, either way, everything was dismissed on that. And, yeah, he's a free man, 100%. So he's going to be moving forward with his civil suit here soon as well, because, man, how do you go from having 5 charges on a criminal aspect, one of them being a felony, another 3, 4 citations, and everything is dropped? Lucky, or we're just maybe doing pretty good. I don't know. Maybe just illegal actions and we articulated very well. Whatever the case may be, congratulations to Jacob. That's pretty solid. Lana, actually, this week as well, we got an announcement for Lana. Lana was going through a lot of shit, man. I actually was listening to her reading one of her transcripts where the judge was like using curse words in the courtroom, like saying an ass and sovereign citizen. Just kind of going wild. And we ended up having to do a lot of work, me and Lana. She was stressed for a little bit, there's no doubt. I think now what she kind of understands is sometimes you don't have to do all the work and you just have to bring forth what you need to orally, because you know it, right? So actually doing all of the work and development allows you to know. That way you're not freaked out while you're in the moment, because you're like, I got all these options. What you gonna do? They're like, which one shall I pick? So it's like, in that regard, it's kind of cool, because you're just like, eeny, meeny, miny, mo. And they're over here like, this person don't know nothing, So, yeah, she went in on this next hearing. She had a lot of correspondence back and forth with her attorney. She was giving her attorney documents that we had developed and researched and put together. And what ended up happening is the attorney came back and was like, I can't file these for you. And if I do, I will lose my bar license. It's like, huh? This is like the most advanced shit ever. Like, you're definitely going to win with this. And nope, wouldn't do it. Very weird and odd. So she went to a hearing, got to speak with the public defender, and then she got to speak to a manager of this public defender, and the public defender is literally like telling her like, oh yeah, well for paid people, you could probably get some of this done because you can tell them what to do, but for us, you can't tell us what to do. We're gonna do what we want to do. It's like, I'm confused, right? So then she gets into the courtroom and they go through the Ferretta hearing, because what the problem was that Lana couldn't get this public defender up off of her to present herself. The judge was like, nope, and well, that got done properly this time, and she stood her ground really good. And then Lana, a while back, we had filed a disqualification of the judge due to issues, and it had never been brought up. It had never been discussed. I think maybe like 2 months now, maybe. And in this hearing, it finally got brought up after the representation was finally established for Lana, and he said, "Do you want me to? Do you want to hold on to this motion that you know? Do you want to accept this and adopt this motion, or do you want to just let it be bygones and me continue?" She's like, "Nah, adopt that shit. You gone, bro. Peace." Smoked him. He's gone. He's gone. Judge gone. Okay, like that. So again, you don't respect our rights. You talk to us like crazy. You show any prejudice or bias upon us in any form or fashion, you will be recused and disqualified. We've done it so many times now. It's not like it. I mean, at first it was like, all right, yeah, we recuse judges. Now it's just like, what? We do it all the time, you know, if need be. Wherever you need disqualification, put it in there, show the bias, argue it out, and we're going to go over a little bit more about that tonight as well. So it's pretty cool. So for all those people out there that say that Cameron James Wilson and his group are hurting people and damaging people, let me ask all of the people here, have we or I ever hurt any single person?
Nope.
Nope.
My eyes hurt from doing all the
No.
reading I gotta do.
You act with
Heck
full
no.
magnanimity,
I
sir.
got this callus on my hand from the mouse, and
Let me ask you, in I guess the best way to put it, are we sovereign citizens though?
Nope.
Sovereign, but not.
I'm a constitutionalist.
Yeah, constitutionalist, more creator-endowed, rights-driven, right?
Right.
Now I don't have a
Trying to
problem
be
calling.
free.
I don't have a problem calling myself sovereign citizen because I know the definition, right?
Yeah.
I'm using the context of back when it was used properly, not what y'all using as it now, right? So maybe I'm a little old soul, a little old mind with that thing, but it's all right. I'll dig that. There's still a lot of people that live in 1910 farmhouses. Okay.
How about
And
this,
Well, the
Cameron?
problem
I'm a-
is the
I'm a-
current definition is related to foreign
Oh.
extremists. And
I'm
the
a sovereign
current
man
to communist extremists or a constitutionalist.
with rights of a citizen.
with rights as a citizen. Yeah, which is an American.
Yeah.
I'm a man.
You're a man. I get it. I'm with y'all. Y'all can go by whatever title you want. I'm just saying, you know. But one thing I do know is, quote unquote, they're concerned.
Yes.
Okay. And that's a big deal because we don't come in like everybody else. We're standing on what we know is true, which is creator endowed rights. We're not coming in on this aspect of we're restoring the great creator back to the forefront. And I think that's what people are scared about. People are scared that we're bringing in that faith and knowing of what we truly are at the forefront, which is causing complications and problems all throughout the rest of the world because you can't beat it. It's all in the Declaration of Independence. It's all throughout everything that we fought for and people died for. The creator endowed rights are real, and they try to destroy God. They don't want you to see you. They don't want you to see yourself as special. They want you to see yourself as a robot like everybody else, right? And that's just not the case. You are special. You are a part of God, a perspective of God, and you need to recognize that and start fulfilling that knowing. Okay.
They've
oh,
had too
thank
long.
you. My mommy doesn't even say I'm special.
Your daddy does
And they should be very concerned. We're coming.
We already
We're
here.
They've
coming.
Yeah.
They should be very concerned because we're coming.
They've had far too long of a run on the complicit complacency and submission and abuse of authority in assuming that we shouldn't be able to ask questions. And in reality, we're the most peaceful out there. All we're simply doing, if I ask you a question and you don't want to answer, you don't have the right to turn or gaslight me when you're the one who has you're the public servant, public office, which is a trust, and you have a fiduciary responsibility to me because you're being paid with public funds.
Right. Straight up. Just like that. All right. So let's see. Can y'all see everything okay?
Yes.
Okay, cool. All right. So first off, we're going to be going through what's called the module 1. We're just going to call these modules. Is this too big? Oh, no. Is it? I think it
Oh,
is.
it's good.
Hold up, Cam. Weren't we supposed to bring up something about that Rex Law thing?
Oh, yeah. If you want to go ahead and do that real quick, you can. Go ahead. That's cool.
Oh, well, I was just gonna say, like, for everyone that's been on Discord, what's that thing called? The Rex Law with the AI or something like that?
Yeah, Westlaw AI.
Yeah. So I did the math. There's usually 50 people in this Zoom. And if 50 people donate about $15 each, there'd be enough for Cam to purchase that for a year. So we'd all benefit from that.
Is
I'm
that a year?
willing.
That's a monthly subscription, not a
The
yearly.
monthly,
Oh,
no,
was it?
it's a year contract. It's
Yeah.
monthly pay, but it's a year. You got to pay. They throw you down for a yearly contract. And I've been emailing them. I'm supposed to be getting a demo, and they're about to give me a 7-day free access.
So, I mean, I know right now there's only about, what, 35 people in here, so...
It's $640 a month though, right, Cam?
648.
7 point, yes.
Wait, that was $640 a month? Or $640
Yeah,
per
it's
year?
A month
It's $648
damn.
per month for a year.
for a year. But what I'll
And
do
a
too is
$99
I'm gonna
cancellation fee if you cancel it.
use it for this week trial when I get it to see, just how good it is. Because if it's not as good, then there's no point, right? I mean, if it's just
I think you're doing pretty good with Manus.
I think I am too, but you never know. When you start getting into Westlaw, bro, you got all access to everything. But what I might just do too is I might build a prompt within a prompt that makes Manus specifically go into Google Scholar to do searching herself, right? Because Google Scholar has a really, really big database. So we might just do something like that. But I'm going to be using it for a week. So we'll see how everything turns out. It's all good. We'll see what's up. And if not, maybe I just got to fork it, We'll see how we can work it out. I don't know. We'll see how it goes.
Boy.
All right. So anyways, this is going to be module 1 for the advanced interlocutory proceedings course that I'm trying to bring forth and just get people to know a little bit more as far as in depths of some aspects and perspectives, because it's kind of like a dual approach here. You got your scales and stuff like that. But I'm honored to guide you through what many conventional legal scholars deliberately, I would think, kind of obscure. And we kind of seen it recently also in Lana's case. Just they intentionally know what's going on. They just won't bring it forth. And that's going to be the metaphysical foundation of the interlocutory relief as an expression of creator-endowed rights. Again, not everybody, but I want to say I don't think we've focused on creator-endowed rights as much as we should have. From the very beginning, I've talked about creator-endowed rights. That's always been my thing. There's nothing that can overcome it. And tonight, we embark on the intellectual journey that transcends the procedural veneer of interlocutory proceedings to reveal their true essence as manifestations of pre-existing natural rights. Not just a merely academic aspect, but it is a transformative knowledge that will fundamentally alter your approach, my approach, all of our approaches to seeking emergency judicial intervention. Before we proceed, though, I do want to invite y'all to kind of consider this one thing, which is, if you've ever sought any kind of relief from a court, did you approach it as one who is like a supplicant requesting discretionary favor? Like, I request the court to do this, I'm asking the court to do this? Or have you always done it or tried to attempt to do it as a sovereign individual asserting recognition of your pre-existing rights?
Always.
You say always, but has it always truly been like that?
I've always gone at it that way.
See, I will honestly admit that I've always intended it that way, but knowing the things that I know now, it may not have come off that way in some of my earlier things.
I think the distinction between these two like approaches in and of itself determines not only your philosophical stance, but also the likelihood of your success proceeding forward. Because when they know who you are deep down inside, they can see it, they can feel it, the energy flows, it's a connection. It really shifts the paradigm in a lot of different ways. So the conventional legal paradigm presents interlocutory relief as a discretionary remedy. Oh, I guess it is. Okay. The conventional legal paradigm presents interlocutory relief as a discretionary remedy granted by courts. Sorry, we'll start that over. The conventional legal paradigm presents interlocutory relief as a discretionary remedy granted by courts when certain judicially created tests are satisfied. This paradigm fundamentally mischaracterizes the nature of the right being asserted. Consider the language typically employed in standard motions for temporary restraining orders, right? So you're just your normal lawyer attorney aspect out there. Quote, plaintiff respectfully requests that the Honorable Court exercise its discretion to grant temporary relief. Hear this one more time. Plaintiff respectfully requests that this Honorable Court exercise its discretion to grant temporary relief. This language, which you've been likely taught to use, you've heard about, it's what's commonly used out there, positions you as a supplicant, okay? A supplicant, all right? Seeking, please, a discretionary favor rather than a sovereign individual asserting recognition of an inherent right that you already have. The conventional paradigm inverts the proper relationship between the individual and the court. It suggests that the court creates the right to relief through its discretionary power, rather than recognizing a pre-existing right that the court has a duty to protect. A duty to protect. Does anyone see the philosophical problem inherent in this conventional approach?
Yeah,
What would it be? What would it be?
it's putting government above man.
Facts. Your belief, your mind, the tricks. It's a lock, it's a tie, it's a prison planet upon your mind. I hate using that term because I think Alex Jones uses it now. He's crap.
You acting like a
Replace
slave
it.
when you do that.
It's given the court the replacement. They're the replacement for the creator.
Yeah, exactly. Good point. The conventional approach presupposes that rights flow from government to the individual, rather than recognizing that legitimate governmental authority exists solely to protect rights that precede it. Already at birth, before you even came into the womb through your spiritual essence of what we cannot comprehend. Interlocutory relief, whether termed temporary restraining order, preliminary injunction, or an emergency stay, is properly understood not as a procedural mechanism, but as a recognition of the creator-endowed right to immediate protection against imminent harm to fundamental liberties. This metaphysical foundation rests upon three interconnected principles. Natural rights exist independent of and prior to governmental recognition. They derive not from constitutional provisions. We've spoken about this. Those constitutional provisions are just gates. They're boundaries. They're there to help protect us. We're already here, flexing on this side of the green grass, partying it up, living life, ups and downs. And we've got this barrier that says, nope, until we go over the gate, you can't mess with us. Meaning that we've done something to lose our constitutional rights. You can't come over the gate. It's protected. It's gold barred. It's electrocuted. Like you try to come through that, you're instantly vaporized. But it seems as though that boundary of vaporization has been turned off. That they can keep encroaching further and further until we're all standing with our backs against each other in a frantic panic at all times. Again, they derive not from constitutional provisions or statutory grants, but from their inherent dignity of the sovereign individual as endowed by the Creator. So we've got creator-endowed rights, and we've got constitutional recognition. We have the right to self-preservation under the creator-endowed. We've got the right to security and property. We have the right to conscience. We have the right to defend against aggression, right? Copy legal. They always want to be like, oh, when a cop makes legal, lawful orders. Yeah, you can say lawful orders all you want. Just because you say when an individual is given, it's like this dude right now over in Jacksonville. It's all over the internet. Window got broke. He got sucker punched. Got a chipped tooth. It's all over the internet. Huge deal right now, right? Funny how none of our window breaks get huge, but his gets huge, okay? Either way, it's great for traffic law reform, right? Traffic law petition, it's great. Works out perfect. But the aspect here is that the chief or whoever was speaking on their behalf was like, when the lawful order is given. Bro, none of what y'all was doing was lawful because Rodriguez versus United States states that you're only supposed to issue a ticket and let them go. You're not supposed to do all this extra investigatory shit. And it's not supposed to even be based on some shit like your headlights wasn't on. I mean, my God, this kid's got a huge lawsuit. And then the right to bodily autonomy. Under constitutional recognition, that's due process clauses, 5th and 14th. Right to security and property is the taking clause, which is the 5th Amendment. Right to conscience is the first. Your right to defend against aggression is second. And the right to bodily autonomy is the fourth. Now, the right to seek immediate judicial, immediate, not a delayed, we're going to get into this, but immediate judicial protection is when these fundamental rights face imminent, irreparable harm. Is itself a creator-endowed right, not a procedural invention. Sorry, that's how it works. So natural justice requires not merely eventual vindication, but timely protection. So when courts acknowledge this through interlocutory relief, they are not creating a special procedure exception, but recognizing a fundamental aspect of justice itself. As the maxim states, quote, "Justia dilata est justia negata or negata," unquote. Justice delayed is justice denied. Think about that. Justice delayed is justice denied. Any comments on that? Some deep ones. Don't give me nothing, just some BS. I want to hear some deep on that. Justice delayed is justice denied.
Continuous irreparable harm. And it's also replaceable time, because the longer you are delaying it, the person, the individual who has been harmed because of the delay in their justice is continually being further harmed as if they were still going through it. And this is the legacy of trauma, and inducing trauma into an individual from the start and then dragging it out is cruel and unusual punishment. That's not justice. You're supposed to have the right to a speedy trial. You're supposed to be brought to a magistrate first off. Everything that's been going on has been bills of attainder, writs of assistance.
Yeah, it's like the conventional legal system seems to believe that telling you, yes, your rights were violated 3 years after the violation is somehow adequate.
Right?
It's like rather like a doctor saying, yes, that was definitely appendicitis long after the patient has expired. It's like, bro, come on, dude. Like, no, it's not that horrible.
Or like
What
my
about
public defender
acting?
turned around and she wouldn't address the slander of sovereign citizen. Oh, but you can go back and you can seek a civil case.
Right. It's like,
You acknowledge that, but you're not acknowledging how it's affecting the situation.
right.
How about practicing law before acting? You make a decision before you even know what the law is, and you arrest someone and you try to prosecute them
Right.
without acknowledging what the law is in the first place.
Right. Nowhere even close within the statutory bounds.
Right.
Okay. So courts do not grant interlocutory relief as a matter of discretion. Okay. They recognize and give effect to pre-existing rights as a matter of duty. Okay. It's really different there. Does anyone see how this shift in understanding transforms the nature of your approach to seeking emergency relief? Instead of a discretionary grant, so this is what we got going, discretionary grant versus duty of recognition. Does everyone see how this shift in understanding transforms the nature of your approach to seeking emergency relief? Yes or no?
This ain't something I'm asking. This is something I'm demanding.
Thank you. The approach is big time different, y'all. Okay? Now, and as you can see, you know, if we're looking at everything here on this chart, you can see court may grant under discretionary grant, plaintiff requests, if the court pleases, seeking the court's discretion, I'm asking for relief. Under the duty of recognition, it's a court must recognize. The plaintiff is asserting, as natural justice requires, declaring pre-existing rights and affirming entitlement to protection. Changing it to a philosophical framework and shape the judicial response. So let me see. Now, let's dive into the metaphysical understanding that transforms the practical approach to seeking interlocutory relief. All right. So the conditional approach begins with statutory and procedural rules and attempts to fit the facts within them. The natural rights approach begins with the assertion of creator-endowed rights and positions procedural mechanisms as mere vehicles for their recognition. Consider this transformation in the opening paragraph of a motion for temporary restraining order. This is the conventional approach, by the way. Quote, plaintiff, pursuant to the federal rule of civil procedure 65B, respectfully moves this honorable court for a temporary restraining order prohibiting defendant from enforcing the challenged regulation pending final judgment, unquote. The difference, a natural rights approach. Plaintiff, a sovereign individual appearing propria persona in sui juris, hereby asserts the creator-endowed right to immediate protection against the imminent irreparable harm threatened by defendant's ultra-vires actions, and accordingly invokes this court's duty to recognize that right through the procedural mechanism described in Federal Rule of Civil Procedure 65B, unquote. Do you see the differences? One is requesting as though they are under, the other is overstanding and knowing within. The difference is not merely semantic. It fundamentally alters the philosophical foundation of your position and consequently the court's framework for consideration. And consequently, the court's framework for consideration. It's rather like the difference between saying, please, sir, may I have some more? You know what I'm saying? And saying, give me that. Okay. So if we're reframing the elements of interlocutory relief, the conventional four-part test for interlocutory relief includes, and you would know this if you've got my book, Self-Governing, bro. You know those four elements, okay? If you've got self-governing, bro, you know them, okay? There's four of them. It's the likelihood of success on the merits, number one. Number two is the irreparable harm. This is, again, a four-part test for interlocutory relief. They must be met. Three, the balance of equities. And four is public interest. These are the elements that must be met. Now, let's reframe each one of those elements within the creator-endowed rights paradigm. The conventional framing asks whether you are likely to essentially win your case. The natural rights framing asserts that a prima facie showing of right violation is itself sufficient to trigger the court's duty of protection. Do you hear me? Do you hear me?
Yes.
The natural rights framing asserts that a prima facie showing of right violation is itself sufficient to trigger the court's duty of protection. So if we're going to say, okay, yeah, let's do these transformations, right? So we've got a conventional language being plaintiff is likely to succeed on the merits because the challenged action violates the First Amendment, right? Or you can move it over to a more natural rights language, which is the defendant's actions constitutes a prima facie violation of plaintiff's creator-endowed rights to conscience as recognized in the First Amendment, thereby establishing this court's duty to provide immediate protection pending full adjudication. Let's hear the first one again. Plaintiff is likely to succeed on the merits because the challenged action violates the First Amendment. Weak. I ain't coming in with no weakness, bro. I am not weak. I am. So let's bring it back down on the natural rights approach again. The defendant's actions constitutes a prima facie violation of plaintiff's creator-endowed rights to conscience as recognized in the First Amendment, thereby establishing this court's duty to provide immediate protection pending full adjudication. Do you see the difference? I guess not.
See a big difference.
Yes, we see the difference. Yes.
Y'all better start talking to me.
Yes, sir.
Let's start talking to me. I'm going to go blank on y'all.
Nah.
Come on now, Ruben.
Participation.
So we go from irreparable harm to temporal necessity, right? So the conventional framing treats irreparable harm as an exceptional circumstance. The natural rights framing recognizes that any substantial delay in protecting fundamental rights constitutes an inherent failure of justice. It's just like Lana was saying. Again, another conventional language aspect, right? Conventional rights or plaintiff will suffer irreparable harm because monetary damages cannot compensate for the loss of constitutional rights. We've spoken about this. Y'all know what irreparable harm means. You know what it mean, what the definitions and the requirements are in Cornell when we've been reading it. But here goes a natural rights language of that same aspect. The temporal necessity for immediate judicial recognition is established by the ongoing violation of plaintiffs' creator-endowed rights, which by their nature cannot be retrospectively remedied through monetary compensation. There's a big difference. The knowing there becomes way, you got to look at it like this. If these judges are constantly seeing this BS that comes through all the time that has the same language because the lawyers all use the same templates because they've all been taught to use the same templates from all the books that they have that have all these templates in there for them to use, and then they come across one who's standing on natural rights with creator-endowed, don't you think they're going to think a little bit more about the actions that they're bringing forth in relation to what they're doing, knowing that we're invoking creator-endowed rights? You think they would think better. Gonna have to get them.
You would think
Hoorah.
so.
We're gonna have to get them. So we're going from the balance of equities to hierarchy of rights. Okay? So the conventional framing suggests a false equivalence between the fundamental rights and governmental interests. The natural rights framing establishes the proper hierarchical relationship. A conventional language again, quote, the balance of equities favors the plaintiff because the hardship of denying relief outweighs any administrative burden on the defendant, unquote. Natural rights approach, quote, the hierarchical primacy of creator-endowed rights over governmental convenience or preference is well established in the natural order and recognized in our constitutional structure, rendering the purported balancing unnecessary when fundamental rights face imminent impairment. Jeez, let's put it into true perspective here. So from public interest, let me see, am I on the right? I'm hoping I'm on the right individual rights and collective interest. I'm thinking I'm on the right slide here. Hopefully I am. Let me check real quick. I want to make sure. How do if I X out, I'm on 12. Okay, I am. Good job, Kim. You're staying up to par. Nice. Okay, good. So the conventional framing positions the public interest as potentially separate from individual rights, right? The natural rights framing recognizes that protection of individual rights serves the collective interest in maintaining the natural order. Now, this is very interesting because this is the approach in which some of our recent haters have been utilizing, right? Oh, you think you're special, and we have to have a body of laws that protects all, and you have to be just like everybody else. What makes you think that you get to be special? Well, they're looking at it in a conventional framing, which positions that the public interest as potentially separate from individual rights, meaning that it's separate and somehow it oversees your individual rights. The collective body now is over the individual. I don't see how that ended up happening, but it has. When natural rights framing recognizes that protection of those individual rights serves the collective interest of maintaining the natural order. Again, a conventional language would be something like this. An injunction would serve the public interest by upholding constitutional values. And a natural rights language would be, quote, recognition of the individual's creator-endowed rights necessarily serves the collective natural right of all sovereign individuals to the maintenance of juridical system that feels its duty to protect pre-existing rights rather than creating them through discretionary grant, unquote. Now, does anyone have questions about how these reframings alter the fundamental approach to seeking interlocutory relief?
I do. I think there's two main factions in the world today, and that's individualism and collectivism.
Right.
And collectivism basically encompasses fascism, communism, socialism, everything except you and I are individualisms.
Okay. Now, but as a gathering with us, that's not the case.
Well,
they put the collective
if
interest
you-
above the individual rights.
That's it. If you put our collectivism above my individual rights and our group wisedome's interest above my interest, then you've taken away you essentially put the collective above my individual.
Yeah. Most definitely.
And that's what has happened across history. And that's how fascists and communists and what we're seeing happening today in our United States of America.
Which is why we here, bro. We here. It's like April said, we coming. We already here, bro. It's already happening. We already got mad channels, you know, probably getting paid to go ahead and do some propaganda and hate, to steer it, because they're concerned. We got it. They're concerned because we got it. We figured out the way. You know, it's kind of like when I'm, you know, Neo. You got Neo, you know, gonna figure out the way. We are all Neos, Trinities, way, right? Then you got Doom, you know. Homeboy finally drank the drink. He got to see the light. He saw the vision, and he said, "Yep, what he do? There's a slim way. I see a way." You know what I'm saying? We found that way, and it's bringing back creator-endowed rights to the forefront. That was the one thing that I think not anybody has really done recently, is bring back the creator-endowed rights and bringing back the recognition that we are that creator. Each and every one of us are that creator. You may not be the creator, but you are you are that spark. Go ahead, Naomi, for real quick.
Just wanted to point out something. I was talking to my mom, and she's in her late 70s, and she was telling me how she was told by her mom, who was born through all of this stuff, whenever the court system seemed to change back in like the early 1900s. And she said, I remember my mom saying, well, you don't want to be one of them sue happy people. And then you're thinking, well, everything is a mini lawsuit. Everything in court is a mini lawsuit. And it was a message fed to her mom that she fed to my mom, and it prevented the knowledge of people doing exactly what this movement is moving forward to do, to assert rights. And that's that generation lost it because some way they were just fed that it was not okay, even though that I think the point was to just be able to do it upon us. So I just want to throw that in there.
Any other comments before we move on?
No, that was spot on.
Yeah.
Yeah,
I'm
go
in
ahead.
my late 70s, and my mom told me during the McCarthy hearings of the communist Red Scares in the 50s, be careful of what organization you join. I was a young man during the civil rights movement of the 60s, and I didn't join any movements or any organizations until Cam founded Wisedome. I
Oh
was
my
an early
God,
joiner.
that's crazy, bro. Okay, now let me ask you this just real quick before we move on then. So since you was a part of that, you know, you living through it, what was some of the propaganda that was being thrown about that was maybe making, yeah, like what was some of the propaganda that you remember from that time? Personally.
It was a lot of Vietnam propaganda.
Yep.
Support your country, doesn't matter whether it's justified or not, a just war or not. My dad fought in the just war, I thought, World War II. I don't know that we've had any just wars since then. In my mind, you guys may have other opinions.
Yeah.
So what the
World War
propaganda
II.
back then was J. Edgar Hoover. We're going to crack down on all you liberal dissidents. Watch your back. We're going to bust anybody that goes against the government. It was a big fear mongering, much like we have today.
Right.
And that's why I fear for my grandsons and you all out there, and why I saw Cam coming along spouting out the word of freedom and liberty, and learn how to protect our rights and stand up, stick your chin out, and learn how to protect the Constitution and teach the word of the Bill of Rights. Excuse me, I get choked up over
We all do.
over this, and I was one of the very first. In fact, I was the very first member of Wisedome.
You helped
I
start
go-
something huge, bro. Just know that you're part of something huge now. Like, just know we millions upon millions upon millions of views now, bro. Like it's pretty cool. Like the message is spreading. The propaganda is here. We got true channels that are just consistently hating on us. It's here, bro.
I think.
Yo,
I think-
everybody say, hold on. Everybody say
Yeah.
thank you to Bob.
Thank you, Bob.
Thanks, Bob.
Thank you, Bob.
Thank
Big
you,
thanks,
Bob.
Bob. Thanks, Bob.
Thank you, Bob.
Appreciate you a lot, Bob.
Appreciate
Thank
you.
you, Baba. Thank you.
I
Love
didn't.
you.
I did. I'm with you. I'm with you, Bob. I did not join any groups because I'm a religious person. I believe in God, and I always felt like God was always missing in all this legal, people trying to do things and processes, and I believe that God was the foundation of this country. That was what they founded it on. And in every single avenue, whenever I can find my rights violated, there's always an exception for religious, and they can't define religion. It's your belief.
Right.
And that meant so much to me reading that, and then hearing this message that Cam has said. I'm like, that's exactly my point. That's how I feel too. And you feel that in your soul when you have creator endowed rights and not just statutory rights.
Yeah.
How about a big shout out to Cam for putting all this together? Thank you, Cam.
What's up, y'all?
Let me do a last couple words
Big
of wisdom, if I may. My mother said it was probably to keep me away from predators. She said, you don't have to do anything you don't want to do. And it was probably you don't have to get in a car with some stranger kind of advice. But I took that word, so you don't have to do anything you don't want to do, to the extreme. And I just didn't do things I didn't want to do. And I got into a lot of trouble because if I didn't want to do it, I didn't do it. Teachers, principals, all sorts of
authority figures.
Authorities. So I challenged authority my whole life. It got me out of Vietnam. It got me out of all sorts of different situations just because I challenged authority and didn't do what I didn't want to do.
Right.
And
I've got a statement to say.
Yeah, go ahead.
I yield.
As far as everybody probably knows this, but for those that don't, what's the purpose of government? The purpose of government is to protect individual rights.
Yeah.
And
Always remember that when you go to court.
And
Their
also,
main job is to protect the individual rights. And I got a paper on Mark, on a guy named Mark Stevens, I think that's his last name, that I gave to somebody, Len, and it all talks about the corpus delicti and whether they don't have a case. I can give that to people if they want it.
my mother also never allowed a firearm. I never had a BB gun. We never had a firearm in our house, even though my dad was a Purple Heart World War II. And yet I get to go to court here August 4th for discharging a firearm. I never had a firearm until I was over 70 years old.
Then they come attacking your ass.
Yeah.
Mitch, post it.
That's
Post
funny.
it, Mitch.
I don't have it on this phone.
All right.
I have to go to the library when I have internet with my computer.
All right, let's pop it off.
Okay, yeah, I yield again.
All right, so we're going to get into applying the principles in relation to drafting a declaration in support of interlocutory relief. Okay. The declaration is not merely, I need to get on the next slide. How do I do this? Okay, cool. I think this one should do it better now, but it's not. It's still kind of, oh no, I don't want to do that. Okay, I'm leaving it alone. I'm not going to touch it. Okay, so the declaration is not merely an evidentiary document, but a sovereign assertion of natural rights that the court has a duty to recognize. Let's examine a concrete example involving a hypothetical case. Oh, why is it? Oh, I was supposed to scroll down like that? Why is it? Are all of them like that? Oh my goodness, that's badass, bro. Why wasn't it letting me do it when I go slideshow? See, it won't. It'll just go to the next page. Yeah, it don't do it right. That sucks, bro. Well, how do you do it right?
Wesley just said to right click and there should be a setting to turn on slideshow.
I know. I'm gonna have to do it like this, which is okay. It's fun. It's fun.
We can see it. Looks fine.
Okay. So, let's examine a concrete example involving a hypothetical case real quick. So we got case facts, which is Jonathan Reynolds owns a residential property in Lakewood, Colorado. He maintains a front yard vegetable garden that provides 40% of his family's food. The city code enforcement has ordered removal based on aesthetic regulations, and compliance would result in immediate loss of food security in rare heirloom varieties. So we got a nice little situation going on here. Do you got it visualized in your mind? You got it? You see what's going on? Do we see what's going on? Okay. How would we transform these facts into a declaration grounded in creator-endowed rights framework? Someone give me an example. How would we transform these facts into a declaration grounded in creator-endowed rights framework? We got
constitutional on the pursuit of happiness.
Okay, on happiness. You got a happiness
Life
claim.
itself.
Can you
Life.
get me the law that empowers what you seem to have as a statute or a code?
No.
What you're looking for?
No.
This is a liberty.
Let me ask you. Let me give it again. How would we transform these facts into a declaration grounded in creator-endowed rights framework? We were just speaking about it.
You need the 4 elements: the likelihood to succeed.
Okay, there we go. Yep. So how are we going to
irreplaceable damages?
Okay.
Balanced equity.
Okay. Well, let's look at the facts, though, guys. Jonathan owns a rental property in Lakewood, Colorado. Okay. He maintains a front yard vegetable garden that provides 40% of his family's food.
Cameron, is he in a contract with the city when he moved into that house that he would abide by the ordinances?
That's not where I'm getting at, guys. I'm getting at what we just spoke about in relation to interlocutory. If we're seeking interlocutory relief, and on that conventional side, we're requesting. Well, now what I'm asking y'all is, through everything that we just went through from beginning to this point, how would we transform these facts into a declaration that's grounded in the creator-endowed rights framework that we've been speaking about?
Irreparable harm.
Okay. What way based on
contracts or everything?
Okay. On what way based on the facts?
God alone says that I can grow my own food.
Affidavits.
That's a big one right there. No, this is a
Sustenance.
declaration.
Living life sustenance.
So you're going to end now my eligibility on being able to grow my own food, which is 40% of what we utilize, because you want something that's aesthetically pleasing. Do you think that's not going to cause irreparable injury and harm? Proficiently, big time.
I'd say we'd have to list the rights that violates this.
Okay, you bring in your irreparable harm aspects, yes. So we're going to focus on that irreparable harm element, okay?
My happiness.
Right. So if we're coming at it though on like a conventional, if we're coming at conventional, the normal lawyerly attorney way, right? Quote, if I am forced to remove my garden, I will lose approximately 40% of my family's food supply in rare heirloom varieties that cannot be purchased commercially, unquote. That'd be something they'd probably use in a declaration, right? But if we're coming through and we're really bringing forth what we know that we are, again, it's a knowing, so it must come out with power. And with power comes conviction. They'd be like, oh, your shit can't be that long. My nigga, I don't know. I have to explain this to y'all because y'all are so simple-minded that you can't understand that I have natural rights that cannot be interfered with. So I must break it down to you because you seem to want to interfere with my life when there's no corpus delicti.
There's no real balance of equity either.
Thank you. Ooh, I need a gavel. Natural. Okay, here's a natural rights paragraph based on what we just said, and I'll read the conventional one more time. Sorry for interrupting. I'll try to be more focused. If I am forced to remove my garden, I will lose approximately 40% of my family's food supply in rare heirloom varieties that cannot be purchased commercially. Us now, on a natural rights type vibe. Forced removal of my garden would irreparably violate my creator-endowed right to use my private property to provide sustenance for my family according to the dictates of my conscience, a harm that cannot be adequately remedied by monetary compensation. The garden contains 37 heirloom vegetable varieties that I have carefully cultivated over 3 growing seasons, including rare varieties that cannot be commercially purchased and that would be permanently lost if removed. What? You're going to talk about you're going to run my rare varieties and heirlooms that I'm creating for the rest of my lineage and beyond that is not GMO'd, that would thereby cause me even more irreparable harm because now we have to go and seek and try and find. You see what I'm saying? Again, it's all about what 3 elements? A disruption of your what?
Natural rights.
No. I'll give you the first one. Life.
Liberty.
Liberty and
Liberty
pursuit of
and
happiness.
happiness.
Which is property.
Okay.
Life, liberty, and pursuit of happiness.
And property. All right, it's property too on that bad boy. Notice, again, how the natural rights framing really is. It explicitly connects the harm to creator-endowed rights. It establishes why monetary remedies are inadequate, and it provides specific details that demonstrate the unique nature of the harm. The conventional approach is rather like telling the judge your car was stolen without mentioning it was only your transportation to the life-saving medical treatments. The details matter, particularly when they connect to fundamental rights. So the metaphysical foundation established must be strategically implemented to be effective. This requires attention to both substance and form. Substance and form. You got both pillars standing here, okay? Duality is everywhere. Substance and form. Okay.
Hey, Cam,
Yeah.
that thing that you got on the screen there looks like it's upside down to me.
Okay.
No, looks good to me.
So we begin with natural rights assertion. In relation to everything that we develop, we have to develop it with explicit recognition of our status as a sovereign individual, which hopefully, if y'all been looking at everything that we're doing, if you're doing things on your own in your own way, that notice is very, very important. You're setting the stage of what needs to be brought forth. We establish the creator-endowed rights at issue before discussing potential procedural mechanisms. 2, connect facts to rights violations. Every factual assertion should link to a specific creator-endowed right. Every factual assertion should link to a specific creator-endowed right. That's why I always try to go back to doctrines and maxims, because they predate all the statutory language that they created. It was already known. It's a natural aspect. It's like the haters, I kind of like it because it's funny, and it makes me really pay attention to things I need to pay attention to and maybe explain a little bit more. So I do appreciate it. That's what a lot of people don't understand, right? Is that some say, well, they talk about this natural law. Well, where is it? It's known within the ether of understanding nature and how nature operates, okay? It's the maxims, it's the doctrines that, again, predate the Constitution, predate the Bill of Rights. It's all through Blackstone's. I mean, it's commentary. It's all over and all throughout bodies of law throughout time. Those things are universal, okay? They're not set in stone in a statutory manner with numerical values next to them, okay? Natural law is flowing, it's knowing. It's within the morality of all existence. We can know what's good or bad. If you have a problem with that, then someone needs to teach you. So number 2 is connect facts to rights violations. Again, every factual assertion should link to a specific creator-endowed right, and then demonstrate how each fact establishes the court's duty of recognition. They got a ministerial duty, link it, show it, bring it forth. Number 3 is to reframe procedural rules as recognition vehicles. So we position Rule 65 and similar provisions as mere vehicles for recognizing pre-existing rights. And then we avoid language suggesting that the rule creates the right to relief. So we go on to 17. I'm on the right one? Yep. Okay. So now we've got conventional term versus natural rights terms. Okay. Oh, will this scroll down for me? Oh, it's overlapping though, just a little bit. Dang, I don't know why it's doing that. It sucks. Okay. So the conventional term of like plaintiff requests, court, linguistic strategies now. Okay. These are linguistic strategies, by the way. You get your conventional terms of plaintiff requests. Natural rights term would be plaintiff asserts. We've been speaking about this in relation to more of the aspects of what Joe's bringing forth, kind of like Kevin as well. The court's discretion under the conventional term versus using on the natural rights side, court's duty. Okay. On conventional side, we see grants relief. And on the natural rights side, we see recognize right. On the conventional side, we see if the court pleases versus on the natural side, as natural justice requires. Or motion for on the conventional side versus natural rights, declaration of right to. So changing just these small terms in and of itself makes a big difference. It's changing the framework and the whole body of law in which they are supposed to look at in and of itself. The linguistic transformation reinforces the philosophical foundation and subtly shifts the court's perspective on its role. That's what I'm talking about. Like, you switching perspectives, body of laws, all the way. It's kind of like language matters. It's the difference between asking someone if they'd mind not stepping on your foot versus informing them that they are currently standing on your foot. Now, I only got 5 toes, so for me, I may not even know whatsoever, and it may not be an issue. And I may be stepping on your foot and not even feel it, but one acknowledges your right to bodily integrity, and the other treats it as negotiable. You see what I'm saying? Naomi, real quickly.
Real quick, I just wanted to say the pyramid that was kind of in question there. That makes a lot of sense to me, the way it was structured, which is why they want to make sure that you are under that court, their legal arguments and language choices. They want to make sure that you feel subservient to them. So they want to make sure that you're understanding rather than knowing that you're foundationally comprehending. That would be my overall comprehension of the situation. So I just wanted to contribute that actually the visual makes a lot of sense to me because we are the foundation. The power is in us. We're broader and wiser, and the power, and then we feed up. But they want to assert dominance, which is why the understanding. Do you understand instead of do you comprehend?
Well, that's why we see what's going on is we're going, I think, into a transformation of ultimate religion.
Yes.
Dying down, right? And in that dying down of religion, spirituality and knowing thyself is on the rise, but that knowing thyself is not unified yet. You see what I'm saying?
Yes, there are so many freedoms.
So hold on. Let me finish this thought.
I'm
Hold
sorry.
on. So as that consciousness rises, there's no unification yet as like a solid source. Now, if I was to say there was a good solid source for such unification of knowing, mine would probably be Seven Bomar. I would advocate for someone like Seven Bomar, Secret Energy, Understanding. If you don't know about him, please, go find my boy. I will happily promote my boy.
Seven Bomar?
Yeah, Seven Bomar. And Understanding or Secret Energy, he can also be found by. But the reason being is because the intellectual knowledge there supersedes everything. It's a very small percentage of people who are able to handle that intellectualism and get their mind frame on upper echelon. And it's very nice to see what he's doing, and I will always love what he's doing, and I appreciate Seven Bomar so much. So Seven, if you get this by any chance, brother, I love you. Wholeness, straight up.
I love that. It's foundational in that there is a higher above the people, but the people are still higher above, and it's not a like the triangle is how they've built it, which is I think what Cam was representing. Am I wrong in that?
Well, yeah, it's again we're going on conventional and the natural rights side right now.
Yes.
So we're
Yeah.
on
So he's building how they have structured it, and not and I just was responding to the other person that said that that's backwards. But
Well,
this is
if I explain it, what's cool is that really all it's showing is that the creator endowed rights are the foundation of all. And that's why I say, like, for us, at least on Wisedome, at least what I'm trying to have people see more of, if they can, is that that should be the basis of everything. Like, I don't know why you're trying to argue the charges when you got constitutional violations on the front end. Do you see what I'm saying? There's no point. There's no point to argue about anything over here when there's bigger aspects over here.
And I see the only cases I see that are so interesting are all about, and I live in Amish country. They're literally like 10 minutes down the road. So I see them standing on that exact foundation all the time
And
of
there's
their
nothing wrong
beliefs.
with it, you know.
No, it's beautiful.
refreshing to
They do
be-
it very well. They do it very well, and it's very effective. And I think that the rest of the world that also knows that they feel it in their soul, but we've been somehow indoctrinated somewhere else or propaganded to something else. And I just wanted to contribute that because I thought I live in Amish country and I talk to them all the time, and their freedom of thought, mind, and how they live is very impactful, and it can be very influential. I think that's a good pattern if it's something brand new to you.
For sure, for sure.
I would like to add to the whole pyramid thing too. When I see that diagram that you have, I don't even see a pyramid because I see a pathway. To me, it's like it's a road. And the thing we all have to remember is this whole system was built off of the symbology. And the idea of a pyramid is it's a few at the top versus the many at the bottom, when we know everything's been inverted. So just keep that in mind. So if you're looking at this thinking it has to be structured a certain way, you need to change your mental structure, because that's what we're doing right now.
Well, I think it's funny too that they even look at a pyramid as up and down like that. What if it was just
Yeah.
in that flat aspect of it? You know what I'm saying? The Trinity is so powerful. So the triangle is literally the Trinity, anyways, right? You have to have two to come together to make another, right? So when we're looking at those aspects of nature all around us, then we can start to just really understand the importance of that Trinity, or in essence, triangle. But again, it doesn't have to be on the upside. It could just be on a flat plane, equal in and of itself,
Exactly.
all three beings.
Exactly. We're bringing back the old symbology that they weaponized against us. The symbology, all of our technology that they have taken from our ancestors, from us, and they have flipped it in their advantage. This is everything that we're doing. Yes. Beautiful.
All right, so let's get, I think, to this one. So we're anticipating and overcoming resistance. That's we're gonna get bit. They're gonna come with it at any point in time, because these courts, everybody's seeing it. We're dealing with it every day because they're accustomed to the conventional paradigm, and it may initially they're going to resist the natural rights framing that we're bringing forth at all times. But that's why you stay firm with it, right? When they be like, comprehend, what's your definition of comprehend? And I have to break it down, for them. And then guess what? They're now using that term. You see how that works? Okay, I'll use comprehend too then, I guess. Yeah, you better, because I ain't changing from it. You know what I'm talking about? But strategic anticipation of this resistance that we're going to have is essential in every aspect. So just be prepared for it, because it's coming. Don't get caught up in it. When they rebut back on what you're saying, just calmly say, well, to my comprehension, and this is, blase, blase, I'm going to be using it, just smile and tell them this is how it's going with me. Common forms of resistance include procedural deflection. Courts insist on conventional framing and want to always utilize that, like I just spoke of. Counter strategy, to comply with procedural requirements while maintaining your natural rights foundation and legalese language. They're going to demand for conventional authority. The courts always demands case law supporting your approach, which is fine for us to use. I don't have a problem with using any kind of case opinion or case law. Counter strategy for that would be to cite foundational cases recognizing the pre-existing rights, using those maxims, using the doctrines, fully understanding them so well that you can articulate them in correlation to the rule of lenity from the statute. Now it can't apply to you. And then also maybe some aspects of saying, well, if it does, what was the original creation of that statute? When was it first created? And what was the intention of its creation by using the whole act rule, right? And so we've got several different, and that's a doctrine as well. And so there's several different aspects of tying in these doctrines and maxims to, again, strengthen your position based on, again, our creator-endowed approach. Then you got 3, which is dismissive characterization. Court characterizes approach as sovereign citizen rhetoric. We love that. That's bias. That's recusal. That's disqualification. Please, speak it some more. Please, so we can introduce an exhibit that shows that sovereign citizens have the highest status within our self-governing republic here in America. Please, so I can break it down to you in a memorandum and get you up off of this case. Please continue to do it. It's not a thing for us. It's not a problem. Again, our counter strategy for that would be distinguish between assertion of natural rights within the legal system versus rejection of the legal system. And what's so cool about this is that when we're looking into the aspect of saying, well, they said it was a sovereign citizen. Why aren't you arguing the aspects of saying all I'm doing is bringing forth sound law? All I'm doing is citing court cases. How does that make me a sovereign citizen? All I'm doing is standing on my creator-endowed rights that was given throughout what this whole great nation was founded upon. I'm sorry, I'm a constitutionalist. I don't see how I could fall into the realms or aspects of a sovereign citizen. But if I must fall into the realms of a sovereign citizen, at least let it be into the context of a 1940 joint resolution that said that I was the highest of status within our self-governing republic. Again, speak it right, man. Let's get factual. Get off the propaganda, please. Can we start raising the consciousness and intellectualism and knowledge within our country? Or will we keep having these fake propaganda Wikipedia flags that are existent upon my channel as though I'm speaking lies? It's not fair, bro. So let's move on to number 19. Okay, so we got recognition of pre-existing rights. Uh-oh. Wait, is this the right one? No, it's messing up. No, you did the wrong one. No. Bum, bum, bum. Well, that's how that one goes. Oh no, it's this one. I'm supposed to be on this one. So I don't know, it's numbered wrong. Yep. Okay, well, at least we got this one, so that's good. I'm happy about that. All right, so we got some cases here. We got Marbury versus Madison. We got West Virginia versus Barnett. We got Roman Catholic Diocese versus Cuomo. Okay, now we're going to read on this one a little bit too, because this Roman Catholic Diocese versus Cuomo is kind of interesting. It really is. All right, so we've got these cases and then the recognition of pre-existing rights. In the Marbury versus Madison, we got the quote, "The very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws wherever he receives an injury," unquote. In West Virginia versus Barnett, we have, quote, "One's right to life, liberty, and property and other fundamental rights may not be substituted to vote. They depend on the outcome of no elections," unquote. That, in a deeper essence, also means to any statutory creation through legislature. You hear that? That's what that means. Am I right or wrong? Can someone validate that one? I know someone's got something to say about that one. Let's hear this again.
That's exactly
right to
right.
life, liberty, and property and other fundamental rights may not be substituted to a vote. They depend on the outcome of no elections.
That's
That's
correct.
perfectly put. That sounds like
You
Supreme
can't tow
Court
your
stuff.
car. They don't own it. It's not an obstruction.
You can't create something that's going to say I'm required, nigga. Like, what are you talking about? They be out here coming to me talking about, you're required. Bro, what are you? Do you know how foolish you sound right now? You literally took an oath to the constitutions and you're sitting here telling me that I'm required. Tell me that one more time now that I've brought that up to you. Because if you do, you know you will lose all qualified immunity, right? Tell me again, because you took it out. Please do it. Come on. Tell me that I'm required. Please, because you took an oath, right? Ignorance of the law is no excuse.
I'm going through this right now, Cam. This very thing. It's close enough anyway. In Long Meadow, they won't let me grow my grass to a certain amount. And I said, but I need to grow it because I use that fresh green grass to be my hay for my growing. And I grow about 40 to 50% of what I eat in my backyard.
Right.
It's like literally almost the same percentage. Oh no, you got it. And they charge me $100 a day. Right now I'm up to $1,400. And then I just got a ticket that they gave me the instructions for. I'll be contacting them tomorrow or the next day. And I'm going to go to that stupid hearing and start to exhaust the administrative remedy and also introduce myself.
Yeah. Oh, this ought to be fun.
Yep. And
Get
they
your
went one
land
step
patent.
further. And then they started charging me for not mowing the tree belt. I let a corner of it get unruly. I always used to mow it. And then I finally said, wait a second, you're making me mow the property that you say is yours.
Yeah, come mow it then.
Yeah, right. It didn't
right.
seem right. So I'm like, so they're going to say I'm under contract and I'm going to say I rebut that contract.
Or you rebut that what? What's how we say it?
They're going to say I agreed to do this.
Rebut
how do
that
we-
shit.
Yeah, I rebut that shit.
Rebut that shit. I'm going to rebut that shit. Right.
Yeah.
Yep.
Yeah. All right, let me keep going. Let me get through this one. All right.
Yep.
So the loss of the First Amendment freedoms in Roman Catholic Diocese versus Cuomo for even minimal periods of time, unquestionably constitutes irreparable injury, unquote. So these authorities have established that fundamental rights exist independent of governmental grant and that the courts have a duty to protect them from imminent harm. Okay. So let's play out a situation again. Oh wait, no. I'm going to go into conclusion. Yeah. Let's do. Is that my last one? Okay. So the transformative power of metaphysical understanding. So as we concluded this first module here, as far as just more of a, I guess, teaching aspect with the visuals and all, what I'm going to do is I'm going to invite y'all to reflect on how this metaphysical understanding and comprehension transforms not only your legal approach, but your fundamental relationship to the judicial system itself. Okay, understanding that instead of it's a duty. Do you understand? You understand they have a duty, y'all?
Yes.
They have a duty to protect your creator-endowed rights. Do you understand that you have to bring that forward if you want that to be done? Do you
That's
understand?
a shame.
You have to have that knowing. You have to have that conviction. You have to have that standing. You have that standing. You learn a little bit of the legalese. You can. The rest will come. You get down on your knees and you ask the great creator. You do not worry and put it upon yourself, and you put it in the great creator's hands, knowing that you're doing it for a higher purpose, not only for yourself, but all future, all wealth, all being, all health. Things will happen. When you approach the interlocutory proceedings from a creator-endowed rights framework, you assert rather than request. You position the court as duty-bound rather than discretionary. You establish the primacy of natural rights over procedural mechanisms, and you transform the four-part test from hurdles to be overcome into manifestations of pre-existing rights. This transformation is not merely philosophical, as it has practical implications for your effectiveness as a propria persona litigant seeking the emergency relief rather than a delayed relief that continues irreparable harm. In our next module, we're going to build upon the foundation to explore the constitutional biblical synthesis in interlocutory jurisprudence, further deepening our understanding and comprehension of the proper relationship between creator-endowed rights and the judicial recognition. Are there any kind of questions right now before we?
Yeah, you know what I get out of this?
What's up, G? Talk to me now.
I get out of this is that when you stand as a person, you're standing under the government. as a corporation. But when you go to court standing as a man, you're standing under these unalienable rights, and you know that what the government's role is as protecting those rights, and you have to turn around and tell the government what their duty is. They have a duty to honor these rights and protect these rights.
Correct, ministerially. So let me ask a couple questions, like to get some discussions going, get y'all talking. Y'all might as well go ahead and unmute now. Get ready for a question. It's coming. Pay attention. If we're examining the Declaration's assertion that rights are unalienable, right? They make fun of us because we say unalienable. You can't put a lien upon us, right? They try to make fun of us. We're saying it that way on purpose. No, we're not stupid. And explore the metaphysical implications of this term, okay? How does the concept of inalienability relate to the necessity of interlocutory relief? I'll repeat it one more time. How does the concept of inalienability relate to the necessity of interlocutory relief?
100%.
No, I'm asking y'all, how does the concept of inalienability relate to the necessity of interlocutory relief?
Well, because they're violating your right. They can't do that. They're making you go through it. They're causing irreparable harm. So there needs to be relief.
There needs to be relief immediately. There cannot be a delay. It has to be done immediately. These are creator-endowed rights must be brought forth again. Why do you think Tanawal's over here preaching about original jurisdiction and indictments and how all this is illegal? Because people ain't understanding who they is. They've allowed the system to eat them up. Now let's go again. Okay, we're going to give another question, see if we can get some more answers. Let's get some more participation, please. Come on, y'all. Analyze Blackstone's, if we were to analyze Blackstone's statement that natural rights are, quote, coeval with our reason and as old as mankind, unquote. How does this temporal understanding affect our conception of when judicial intervention becomes necessary?
When we want to assert our rights and when we need relief.
Right away. It becomes
Right
necessary
away.
right away.
Right away. Now, what happens when they're not honoring that, though?
Treason.
Okay,
They need to recuse themselves.
You need to bring it forth. You need to bring it forth.
We need to bring it forth.
Yeah, you got to bring it forth.
This
If
seems
you're-
like it would be especially useful in CPS cases when children are involved. You know?
Great
Oh,
point.
yeah.
Great point.
Wow.
Because they like to kidnap them bitches, and then they don't even let you near a judge.
Well, here goes another one for y'all. Consider the implications of the ontological distinction for corpus delicti doctrine, okay? If you don't know what corpus delicti doctrine is, you're about to know. If rights are creator-endowed rather than state-granted, how does this affect the legitimacy of victimless enforcement actions?
It nullifies it. Void.
Yep.
From
Void.
when?
Yeah, I was
Ab
gonna
initio.
say, it doesn't
Ab initio,
From the
from the
beginning.
beginning.
Conception.
Yeah, right. Okay, so let's explore the relationship between the ontological status of rights and the irreparable harm doctrine in interlocutory proceedings. Why does interference with creator-endowed rights inherently constitute irreparable harm?
You're going
Because-
against my God.
Yes.
To not
Ruben.
have them becomes a time span you can never get back. It is, in fact, by definition, irreparable.
So what happens is, again, we're bringing back the aspect of, we're showing that your laws are actually against God. Your laws are against faith. Your laws are against religion. Your laws are against freedom. Your laws are against sovereignty. You're showing it in your conviction. You're showing it in your violation of your ministerial duty. You're showing it in your malicious prosecution. You're showing it in your violation of ethics. You're showing it in the disruption of my life, liberty, and the pursuit of happiness. You're showing it in relation to the private and public nuisance that you're causing. I mean, there are so many elements that can continuously stack on and on and on.
But in common law, that's basically a common law trespass. Immediate trespass and harm done. like you
God,
said.
God gave man dominion, and the man created government to administer that dominion, not have dominion over man and the people.
Facts.
It was the agency factor. Them having agencies, which really screwed things up. All the way from utilities to taxation districts, all the way down. I mean, you're never going to find your rights anywhere in the motor vehicle code. You're going to find them in transportation code.
So, of course, in the Declaration of Independence, we hold these truths to be self-evident that all men are created equal and that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. It states it right there, that they are endowed by their creator with certain unalienable rights. What you talking about? Where is natural rights? Where do we get natural rights? Clearly, I'm getting my natural rights from the Bible. Clearly, I'm getting my natural rights from the
from nature herself.
Bhagavad Gita. You know, I'm getting the deeper understanding even of nature. I'm getting some of my understandings as far as my creator-endowed rights from Confucius. Sometimes I'm getting them from the preachers today that I hear some quotes every now and then, or the spiritual leaders such as Seven Bomar. Right? What do you mean? It's a knowing. You know it. It's within you. It's morals. It's integrity. It's honor. It's not written even. Most of them aren't even written. It's just knowing internally. And then again, those rights, then, which God and nature have established and are therefore called natural rights, such as life and liberty, need not the aid of human laws to be more effectively invested in every man than they are. Neither do they receive any additional strength when declared by the municipal laws to be inviolable. That's exactly what's happening.
Yes. Can I make a
how are
statement
we
on
gonna?
that?
How are they charging us to live in a universe that we're born into? uh, I just don't understand that. I was born into the universe, and there's water, there's plenty of food, and they're just selling us
Because they can make
water, everything.
off of us.
The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied to the courts. What happened? What they got going on?
I'll rather say that again.
The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. Are they applying the Bill of Rights to the courts?
Not
By
anymore.
no means.
It's all commerce. They turned us into commerce,
Don't you talk about that stuff in my courtroom.
right?
You know what I'm saying?
It's all about credits to them.
I got a comment to say again.
Yeah, go ahead.
Okay, before I've talked about this, that like entities can sue like entities. Man can sue man, but a corporation cannot sue a man because we're at a different level. We're at an alien rights level, and that's why they've developed this system of a person to be part of a corporation that try to get us to step into this person aspect to control us and tell us what to do instead of us standing on our footprint of a man and looking down on government and saying, hey, you work for me, I don't work for you. You have a duty to protect my rights on an individual basis. But they want to get us all into, society and safety aspects to overrule all these unalienable rights.
Right.
It's like we forgot how to invoke our rights for so long. We forgot how to exercise that muscle for so long that they were bored and they thought they were just going to build this whole thing against us. So that, well, not, I don't know whether it was against us directly or it was however it manifested its little tiny minuscule statutory ways, but it was to pressure down because the courts were there for us to address our grievances against another human being. And then we lost the functionality because we didn't want to be, as well, as my great grandmother says, sue happy. and so it deterred us naturally. And I think that's where it was kind of indoctrinated through propaganda to not be so happy. And
I remember that.
yeah, not be sue happy, and don't sue people, just leave them alone. But that's where we lost the education, because prior to that we were exercising those rights. Right before that, before my great grandmother was told that it was not okay to be sue happy.
You know where that started? It started in as it relates to your neighbor. And with that, I agree. So when the dog bit me or our dog bit our neighbor's kid or whatever, you don't sue the neighbor. You make sure everything's okay.
Yeah, you
And
make
it-
that's
They-
what
that which is different, and it got
provide.
morphed into what you're saying. Totally.
They
down to that
signed
whole
the
self-governance
Emancipation
thing.
Proclamation and lost a lot of income, so they needed to make everybody a slave again. Instead of just the Negro making them slaves, they made everybody a slave.
Correct.
Good at it.
The commercialization.
Yeah,
of
we
the-
are presumed indigent until proven otherwise.
Well, we got all kinds of people.
As fact-based in Lana's situation, which I absolutely thoroughly enjoyed listening to that. That was amazing, super empowering. I was like hooting and hollering in my kitchen.
Yeah. Too.
You know, they were very much, it was, you were indigent until you could prove yourself not. And indigent has a very broad, I mean, they say it's statutorily a certain amount of income, but we know that they don't always adhere to that.
But again, that income is based on you being an employee in their system.
Right. And so did they ever ask you how much you made for a living? Like how much
I
you
did not provide or volunteer shit.
Correct. I know, I heard that. So whether you were indigent based on your income, as their premise was for their statutory regulation of why you were provided with public counsel, if that's the definition that they're going off of, why did none of those questions have anything to do with whether or not you were quote unquote indigent making less than $25,000 a year?
I'll actually tell you the little secret that I didn't share while I was on that. I was there on Monday because I was like, you know what? Here's the deal. When I went to the first arraignment on May 19th, it was about me challenging jurisdiction, and I stayed on it. And he railroaded me. I have the video in all the audio for all of these. He railroaded me, and he forced the public defender. In the docket, it said something about Feretta hearing, but there was never a Feretta hearing. He never asked any of those questions. So when he said it was the third time this on Monday, I had a moment of like, I'm not going to correct him because it was only the second time. What he did is he forced the public defender with no Feretta hearing, and that public defender and her supervisor were never present on that day. The next hearing is when I didn't know what was happening, because here I am just forced this public defender. And I'm like, well, I will say this. In the court hearing on that arraignment, he claimed I needed to go down and fill out the paperwork. But when I went down and I said, what is this form for a public defender? And they're like, such and such. And I said, oh, I don't want a public defender. And they said, well, you don't have to fill it out. This is how I operate in life. I'm like, why would I fill that out? Because that's like a voluntary contract.
Yep.
I did not agree to it. He proceeded to force a public defender on me. Why was I going to make that easy for them? So it was funny. And I was biting my tongue because here's this guy, her supervisor, when you're listening, basically expressing, well, I don't know, because he's worried about getting paid. Let's just say that it was about the bottom line. He's like, well, I don't know how you got a public defender if you didn't fill out, like he's sitting there completely perplexed. You would have laughed to see him visibly. And I'm just like, I am not volunteering information here because I know exactly what happened. And as it was, they gave me the obstacle and the challenge of having to deal with that, with the public defender not being able to file anything that they would take notice on. So I just left it alone. I'm like, I'm not volunteering information because they don't deserve it. So the long story short on the indigent thing is that you can't force someone to fill something out. That's a Fifth Amendment violation again, too, right?
Yep.
It's all self-incrimination. I didn't even like answering the questions that he was asking that had no relevance to competence.
I saw
But
that.
I just-
I heard that and I thought that was so amazing. And I was like, yes, what does any of that have to do after listening to the public defender's office say, she said, I will give her a little bit of credit because she was like, yeah, there's obviously things that we should be doing, but we haven't dealt with this.
Yep.
And I love that. Just in the context that they haven't dealt with it, but she didn't dismiss it. She did not outright dismiss the validity of it. She must be like at least relatively new in law.
Well, she just graduated law school in April.
Good for her that she's still not indoctrinated enough
Being
that
groomed.
she can still see some form. I'm sure that will be lost soon, unfortunately, but hopefully not. But Lana, I have to just tell you, I literally was hooting and hollering. I've been waiting to hear the anything beyond like the actual like interactions, and I just wanted to give you super praise. Everybody say, great job, Lana. You did so good.
Great job,
great.
Lana.
Great job, Lana.
Great job. It was the best.
It really was the best.
Did you guys play that in the first hour?
No.
No, it was it was posted on YouTube earlier today. So if you
Oh,
have
is that the
not heard
YouTube
it,
video that was posted in the chat?
I was just watching that before we came to Wisedome.
yeah,
I'm dying to
it
see
was
it.
it was really great, Lana. And
Thank you.
it was very empowering to me as well. I just want to let you know that because I feel like that energy kind of, perpetuates when you receive somebody's energy and somebody's like willing to put it forth. And so thank you for that. I received that energy and I love it.
Yeah,
Thank you.
Great job.
Thank you, Lana.
Return that energy too.
Great job, Lana. To answer the question, if you don't mind, what would have happened if you did not answer the questions for that judge?
I'd still have a public defender.
Oh, okay. I didn't
I
catch
was
that.
honestly, and then the icing on the cake that you heard the audio. His energy, he was actually, like when we talk about our energy needs to own the room. And this literally I had a moment, for over a week, I was like in surrender mode because I wasn't really feeling like I needed to over prepare. And then there was the whole question about whatever I filed not being seen. And then when I went in, the only time I was really like a little unnerved was when I was sitting in the same spot that I sat the last time, not knowing what exactly was going to happen just yet. But going into that side room and talking with the public defender gave me an opportunity to reset. And that when I went in there and I was the last, case, the prosecutor had his laptop up there talking with the judge at the bench, which I think it's an ex parte thing, like these guys are all buddies. We all know that they need to recuse themselves because they're all working for the state. They're all getting public funds. They're all colluding and conspiring, all the things. But when I walked in, I literally, there was a moment when I was standing and going through these questions that I looked at the bailiff and and Kendra said he couldn't take his eyes off of me. and I know what it was. I have a certain necklace that I sometimes wear that's a power piece that people are drawn to like a moth to the flame. And there was a moment because I was so grounded and I just felt like I've got my protection on. I've got God watching over me. I literally felt like I had them in a trance. And I say that because the judge was mirroring more of my energy than the last time when I was probably mirroring more of his. And when he got to the end and he was telling me how I would have to refile the motions and all the things, and then he just turns around and he was very much nervous about, and well, there is this one, yeah, let me find it here. This one thing that I procedurally have to, address. You know, like he was kind of tongue tied. Like he got his jab in to go through the Feretta hearing, but then when he got to the bringing up the disqualification and recusal, and I didn't really quite catch that last little blip where he said such and such and or adopt, and I thought, huh, wait a minute, can you clarify that? Because I didn't hear the word before what he was saying. And he said, well, I can't, but basically you can choose to withdraw or adopt it. And I was like, fuck yeah, I adopt it. And when he recused himself, I was like, okay. So in my mind, because I sent the letter physically as well as email to the chief judge and the JQC, I'm like, it's very possible he got a heads up. You know what I mean? Like he might have gotten a phone call.
I thought it was so brilliant, Lana. It is a terrifying situation. And then for those of us that don't have the natural gumption from the masculine energy, which is not a bad thing, it's a good, healthy thing. Masculine energy is very important. I love it. But for those of us that don't have the masculine energy, I was just so proud of you from womanhood. I was so proud of you for whatever that means to you. I just wanted to project that. I was like almost in tears. I was so excited listening to you. You were so strong, and it was a very big that was a big moment for me.
Thank you.
It was a big moment for me.
I also
I've been through a lot, and I'm sorry, getting emotional, but that was huge for me. Just listening to that strength, I felt from it. I fed from it. So thank you.
Thank you. And Kendra, having Kendra watch from behind too, she said the moment he said he recused, she didn't know what it meant. I was like, she said your shoulders just dropped. Like she watched my shoulders drop. And I was like, oh, I felt it. I know it did. And so we were walking out and she goes, well, what does all that mean? And we walked out. I said, let me tell you in a second when we got out of the building. I said, basically, I had put in a recusal like 2 months ago and he just recused himself. So now it goes to another judge.
Can you tell me how you were actually able to record that? I cannot seem to sneak a single recording device.
I'll tell you what, this is a recorded call. This is a recorded Zoom.
Oh, it is recorded. Okay, send it in the chat. Send it in the chat, please.
Yeah.
I'm so frustrated because I can't record any of my hearings. Or at least I'm told I'm not. I'm frisked down. The whole thing, just walking into the public courthouse, and
put it in a media request.
You can do that too.
Yeah, you can do that too, but I feel like that's not the way that has been done, because then then the judge knows he's being recorded, and I don't believe that the judge needs to know. I would like his natural responses and his natural ridiculous responses to things. So
Did you see the video Doug posted about the absolute defiance guy?
No.
Yeah. He walked straight in there with his cell phone, basically stating, screw you guys, you're not going to stop me. It's the judge's opinion. I'm not allowed to do this. It's not a law or a rule. I'm not allowed to bring this in here, and just stood on it.
Yeah, sometimes you just gotta stand on your shit, bro. Like, I have a right. I'm going to record any proceeding or any place I'm going to be in. If you don't want to point it at you, fine, but I'm going to point it at myself. I'm going to make my own personal record, and you can't stop me from doing it. And if you want to go ahead and violate my rights, go ahead and recuse yourself now.
Exactly.
There's any point to argue about this, Your Honor. So I'll continue to call you Your Honor as long as you act in it. If you want to find me in contempt for the reasoning in which I'm bringing forth right now and today, then so be it. All right, Ty. What's good, Papa? Do you want to tell some of the complications of what we've been finding out in relation to your situation? Actually,
Ask
real
me a
quick.
question.
Well, I still want to go through the interlocutory, but I feel like if we did 2 hours of an interlocutory and we let the third hour and beyond kind of be a little bit more loose, is that okay with y'all, or y'all want to keep going with the interlocutory? Because I got some more.
Interlocutory.
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 All right, I got a good example of that. We'll go into Ty. Ty, we'll circle back around to you here in a second, bro, because this shit's actually pretty fire. This comes back to the Catholic Diocese that I was speaking about earlier in relation to everything, okay, as far as your interlocutory.
Can you state the whole case of the Catholic Diocese again?
Yeah, so it's Diocese of Brooklyn versus Cuomo. Versus Cuomo. And it's so the factual and procedural background of the case itself is that in Roman Catholic Diocese of Brooklyn versus Cuomo, religious organizations challenged the COVID-19 restrictions that limited attendance at religious services while permitting comparable secular activities to operate under less restrictive standards. The case arose in the context of New York Governor Andrew Cuomo's Executive Order number 202.68, which imposed occupancy restrictions on religious service in geographic areas classified as red or orange zones. Kind of sounds very similar to those who wish and seek to desire to have their right to travel from their creator on things that they've dictated, highways and byways, you know, and I thought they were thoroughways, if I wasn't mistaken. A lot of these highways, y'all don't even understand. Those are ancient pathways that go from up to Canada all the way down deep into Mexico. And they've been there a long time. The mound builders are known to have pathways and paved roads that go all throughout middle of America. So, yo,
My ancestors came to Oregon before Oregon was established, a corporation.
Sheesh. So let me see, we got in the red zones, houses of worship were limited to 25% of maximum occupancy, or 10 people, which is whichever was fewer. In orange zones, the limit was 33% of maximum occupancy for 25 people, which was whichever was fewer. And then simultaneously, business deemed essential face no comparable numerical restrictions, even when they involve similar gatherings of people in enclosed spaces. The Roman Catholic Diocese of Brooklyn and Agudath, Israel of America, separately filed suit in the United States District Court for the Eastern District of New York, seeking injunctive relief against enforcement of these restrictions. Both plaintiffs argued that the executive order violated the free exercise clause of the First Amendment by targeting religious practice for especially harsh treatment while exempting comparable secular activities. The district court denied the applications. Now listen, check this out. The district court denied the applications for preliminary injunctions in both cases. And the Second Circuit Court of Appeals declined to issue injunctions pending appeal. The plaintiffs then filed emergency applications for injunctive relief with the Supreme Court under the court's shadow docket, a procedural mechanism for emergency relief outside the court's regular merits docket. And on November 25th, 2020, the Supreme Court granted the emergency applications. Uh-oh. So you see that? 2 denials on the lower one to bring it up to the higher and finally get it done. But in the process, there's a whole bunch of irreparable harm.
Bring it forth.
You see what I'm saying? Okay.
Never heard about a shadow docket.
The Supreme Court granted the emergency applications, issuing an injunction prohibiting enforcement of the challenged restrictions pending disposition, of the appeal in the Second Circuit and subsequent petition for certiorari if filed. This extraordinary relief, issued through an unsigned per curiam opinion with several concurrences and dissents, demonstrates the power of higher law principles in contemporary interlocutory practice. While the court's per curiam opinion employed conventional free exercise clause analysis, several aspects reveal the implicit invocation of higher law principles that transcend mere positive enactment.
Cam, you got to go back a second. They said extraordinary relief. What the hell are they saying? Our relief isn't extraordinary. Their actions are extraordinary. Did I hear that wrong?
Extraordinary in the statute. Well, extraordinary. Well, no, you didn't hear it wrong.
All
But
right.
in relation to the executive order, it would be extraordinary, right?
Okay. Yeah. That they would even frame it that way when there's only one extraordinary when you start getting up to that level.
No, I hear you on that, but I think it's
Yeah.
more in relation to the executive order.
Good enough.
Personally. Okay. So the court declared that the loss, quote, the loss of the First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. Damn. Damn.
Who said that? This New York Supreme Court?
This one's coming out of Elrod versus Burns in 1976.
Oh, U.S. Supreme Court.
What's amazing is it really fascinates me to not really get deep into the thicket of things here and think. If I'm in a tough spot, if I'm low and I feel like raising my spirits, I might want to praise God. I might want to give gratitude and thanks and really start to appreciate the things that I have rather than looking at the things that I don't have, right? And if one of those ways for me to do that is to get onto my motorcycle and ride in the wind, feel the wind pushing against me and just feel the physics of this reality and feel the sun shining upon me, and I find gratitude and looking at everything amongst me is just, I really find pleasure, and it's a way for me to give thanks. My pleasure is almost a way to give thanks to the great creator, right?
Right.
I'm sure that satisfies God. I'm sure that satisfies all creation.
Oh yeah.
If I'm disturbed in that, you're taking away my First Amendment rights on those roads.
My happiness.
They don't see it that way. I see it that way. So if I see it that way, you need to bring it forth that way. It's deep. And if anybody tries to go against that, then they're going against your First Amendment rights. But you have to articulate it. Again, the conventional method of speaking and bringing forth versus your natural rights, creator-endowed rights aspect, which is the depth of morality, integrity of the creator-endowed rights.
Life, liberty, and the pursuit of happiness.
I'm telling you, on its depths, the foundation, you cannot get over that. I can always bring anything back to that, and it will always be a violation because I do not harm other people. So anyone telling me or you what to do will be a harm against another person without reasonable, articulable suspicion of a crime. Why is that a problem? I understand the aspects of the roads of being safe, not running speed signs. That's great. That's good. We abide by those. I think we all want to be safe, okay?
Yeah.
The statement reflects natural law, understanding that certain rights violations are inherently irreparable regardless of the duration or the magnitude. It doesn't matter. They'd be like, oh, they broke his window and then they punched him. Okay, so because they punched him, did it make it worse?
Yes, it did.
Yeah.
Wait. What I'm saying is, did it make it worse? You're not getting it. The statement reflects natural law, understanding that certain rights violations are inherently irreparable, regardless of the duration or magnitude.
Yeah. So I'll start.
Regardless
It didn't
of
make it worse.
Okay. Of course it makes it worse. You got another stack on top. But what I'm saying is the breaking of the window is that damage, that the pain that's caused, the anxiety, the fear.
The stop itself, those red and blue lights, that's it.
Then the family element, daddy's not home, daddy got arrested, mommy got arrested. That's all deep irreparable harm. What did my daddy do? Now the kids are questioning if daddy's a good daddy. I mean, it spreads so deep.
We forget the impact of irreparable harm because we are taught to not have emotions unless it's somebody else enforcing their emotions upon us.
So the
And
court did not require conventional evidentiary demonstration of specific harms, but recognized that the mere fact of rights violation constitutes irreparable injury, warranting immediate judicial intervention, immediate. This principle aligns with the metaphysical reality that the creator-endowed rights exist independent of and prior to governmental recognition, rendering any infringement inherently irreparable regardless of practical consequences. Regardless of practical consequences. Okay.
There's some key things there that our rights exist before the recognition of government.
Yeah.
Here's where the judges go wrong. Is they're there to protect our unalienable rights, but they ignore them when evidently when it comes into court and they say that we busted the window. Well, the judge should speak up and say, well, doesn't he have a right to his own private property? And why are you damaging his private property? He didn't stand up for no rights. And they do this state commercial thing that they are above everybody and assuming that they have a contract and they can treat us any way they please.
The court's use of unquestionably emphasizes the categorical nature of this principle, not a matter of judicial discretion or balancing, but an ontological certainty flowing from the nature of rights themselves. The court emphasized that even in a pandemic, quote, the Constitution cannot be put away or forgotten, unquote. This statement implicitly recognizes that constitutional principles derive from sources that transcend temporal emergencies or governmental convenience. Governmental convenience. It's a convenience for us to monitor these roads. It's a convenience for us to come out here and take your kids. It's a convenience for us to say that you're interfering when you're standing on your rights. It's a convenience for us to search your property without a valid warrant and then charge you later after we've already violated your constitutional guarantees and liberties. It's like it's outstanding. The Constitution is not merely a procedural framework that can be suspended during extingent circumstances, but embodies principles of higher law that maintain their authority regardless of practical challenges. This understanding aligns with the natural law that we've been speaking about all night, traditions, recognition that certain principles transcend positive enactment and maintain their binding force even when compliance proves difficult or inconvenient. Again, if there's anything that's brought forth that violates my rights, it's a nullity. I can operate on that right with impunity. I do not have to worry about these people trying to impose anything against me. I am not worried in everything that I bring forth because I know who I am. I know the law. When they come to me and be like, oh yeah, where'd you learn that from, buddy? You need to check your sources. What do you mean? The municipal and county codes? Your own municipal and county codes? No. What do you mean, no? Go read, bro. Quit questioning us as though we're not reading or that we don't have a comprehension of who we are. So Justice Gorsuch's concurrence explicitly invoked the metaphysical foundation of religious liberty, noting that the free exercise clause, again, this is so important, religious liberty, okay, that faith and knowing, guarantees the free exercise of religion, not just the right to inward belief. Guarantees the free exercise of religion. That doesn't mean just gathering. That doesn't mean just I believe it in my mind. That means exercising your God-given freedom to be free. Do you understand? Your right to travel is a God-given. You have the guarantee to freely express that faith and knowing. Don't just limit it to the word religion. Creator-endowed rights supersede everything. The foundation, the basis for everything moving forward. This distinction between internal belief and external exercise reflects natural law understanding that rights encompass not merely abstract principles, but concrete manifestations in lived experience. I live my faith. I live my experience. It cannot be taken from me. It will not be succumbed. It will not be stifled. There will not be limitations on my requirement other than those in which I know that is of natural law. Speeds, looking out for other people, is natural law. You have a duty as an American. Justice Gorsuch further observed that the government is not free to disregard the First Amendment in times of crisis, emphasizing that constitutional principles derive their authority from sources beyond mere governmental convenience or emergency circumstances. This understanding again aligns with natural law tradition. Then the court emphasized that religious exercise cannot be subject to the mere restrictive treatment than comparable secular activities, reflecting that natural law, again, understanding that all persons stand equal before the higher principles, regardless of the governmental categorization. Jeez Louise. Okay. So the several specific quotations from the court's opinions on this one warrant detailed analysis for the reflection of natural law principles. The loss of the First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. It's a big one. First Amendment freedoms, life, liberty, pursuit of happiness, your faith being exercised. It's not just, I get to believe my religion inside. You also get to exercise that. I'm going to ask a question. Please unmute. Does your faith, does your spirit, does whatever you live for, does it believe that you can travel freely? Or does it think that
yeah.
Yes, it does.
Wholeheartedly.
It knows it.
Absolutely.
Travel and
I don't believe.
educate.
I don't believe. I know. My faith makes me know.
Exactly.
Thank you. So this quotation drawn from the 1976 case Elrod versus Burns and reaffirmed in the Roman Catholic Diocese establishes that certain rights violations inherently satisfy the irreparable harm requirement for interlocutory relief, regardless of the duration or magnitude. Do you hear that? It don't matter how big or how small. It don't matter even how long it happened. Just that little bitty of it is enough to satisfy irreparable harm. Okay? So now we're starting to look at, well, damn, Cameron, from the statutory conventional side that you're talking about, those four elements that must be met are kind of null and void if you have any constitutional irreparable harm aspects even being brought in. Looking at it from this perspective, right or wrong?
Right.
Bring it forth. The court's use of unquestionably, not a matter of judicial, okay, yeah. Okay, yeah. The court's use of unquestionably emphasizes the categorical nature of this principle, not a matter of judicial discretion or balancing, but an ontological certainty flowing from the nature of the rights themselves. This comprehension aligns perfectly with the metaphysical reality that the creator-endowed rights can exist independent of and prior to governmental recognition, rendering any infringement inherently irreparable, regardless of practical consequences. The temporal dimension emphasized in even minimal periods of time, quote, even minimal periods of time, reflects natural law understanding that justice cannot be delayed when fundamental liberties face interference.
I'll stand on.
You better, shit. Even in a pandemic. So we're talking about even in the most extraordinary times, the Constitution cannot be put away and forgotten. This statement, which can be used at any point in time for y'all, establishes that constitutional principles maintain their binding force regardless of the temporal emergencies or practical challenges. The metaphor of putting away the Constitution suggests not merely procedural suspension, but substantive disregard for principles that transcend positive enactment. What is positive enactment? I'm going to wait for it.
Positive law, positive enactment would be that side which is public law, not just public policy.
Yes, they're new creations, they're new statutes that they're doing all the time, right?
Well, no, I'm saying the public law is
But a
what's
positive
actually the,
enactment would be
Positive law would be equitable law with natural rights.
okay. Equitable law, positive enactment. See, I'm getting this one confused. Okay, I'm going on the negative, right? Switching the two up. That's what's going on. Okay, so I don't need to look at it. We good.
Am I mixing that up, Cam? I'm sorry.
No, y'all right. Because I'm getting negative. I'm flipping it. I think on my comprehension there. Okay, but again, the context of it is saying, but substantive disregard for the principles that transcend positive enactment.
Any enactment.
That's what I'm thinking too, because the context of the sentence is leading me to believe that any enactment that they bring forth, positive to, they're saying that it's positive in relation to, oh, we're helping society. You know,
it's like positive law. You know,
yeah.
positive. Yeah.
Yeah.
Yeah,
So this
that word Positive has a very distinct meaning. Positive law is that which is the constitutional part of it before it goes
I
on
don't
to
think they're looking.
statute
I don't think
shopping.
that. I don't think that term is coming in it like that, though. I think,
Okay.
but I may be mistaken. So please correct me if I am. Okay.
I'm not sure. I guess read on.
I'm not firm. Yeah, I'm not firm. I'll bamboo on this one. So I'll sway. My aspect here is if I'm thinking at it just from the way I'm perceiving, right? Perception's everything. So the way I'm looking at it is they're enacting these things thinking that it's positive because people are complaining or people are wanting things. So they say, oh, we're enacting this for something positive, right? But it's only positive to the corporation and not to the people. So this understanding aligns with the natural law tradition's recognition that certain principles derive their authority from the sources beyond mere governmental convenience or emergency circumstances. The Constitution is not merely a procedural framework that can be suspended. I'm not caring about that one.
Positive enactment in legal context refers to the formal process of creating or establishing laws through the authority of a legislated body.
Okay, well, perfect. That was on point. Damn, good. Let's go, baby. All right, so, quote, government is not free to disregard the First Amendment in times of crisis. At a minimum, the amendment prohibits government officials from treating religious exercise worse than comparable secular activities unless they are pursuing and compelling interest in using the least restrictive means available. They sit here and be like, oh, the license, is a requirement. You must have it. But then you ain't talking about you pulled me over because I did anything wrong. Like what? It's axiomatic, bro. This statement from Justice Gorsuch's concurrence emphasizes that constitutional principles derive their authority from. What was you gonna say? What was you saying?
No, go ahead. Sorry.
It's all good, bro. Ain't nobody tripping. Support use in the rights, emphasis, how far is on transcend authority against emergency powers, equity before the higher law. Okay. Now, the court's emphasis on equal treatment between religious exercise and comparable, again, religious exercise. A lot of people be seeing that as very limited. I see that to expand out. The exercise of my faith and my belief is to experience and encompass the life, liberty, and the pursuit of happiness. I'm showing gratitude. I'm experiencing. The great creator is benefiting from me appreciating. Like, man, bro, I'm about to start getting deep with it for real. Classification cannot justify desperate treatment of activities protected by higher principles. Again, right to movement, right to travel. Wisedomians can apply this principle to challenge enforcement actions that subjects creator-endowed liberties to more restrictive treatment than comparative activities. Again, this principle applies with particular force to selective enforcement of code provisions against those asserting creator-endowed rights, the basis that cannot be broken. When a municipal corporation enforces a victimless code provisions against wisedomians while ignoring similar conduct by others, the litigant can invoke Roman Catholic Diocese to establish that such desperate treatment violates principles of equity before higher law. Now let's figure this out for a moment. We got who all out there to get exemptions on them roads? Yo, put one on the page, please. Who all gets exemptions on them roads?
I'm working on the exemptions on them homes.
No, who all gets
those who seek the privilege.
Okay, who all gets exemptions on the roads? Can anybody name anybody that gets exemptions? Why they get
State
exemptions?
officials.
Okay, state officials. Who else?
Those who have to deal with it as a privilege. Those dealing in the de facto privilege system.
In the privilege realm, who gets exemptions?
Religious, educational, school buses, religious buses, transport versus in my constitution and state code.
Okay, let's do this. Farm trucks, right? Farm trucks.
Political figures.
Okay.
Postal workers.
Postal workers. Thank you. I was gonna say that one next.
Diplomatics.
Church bus.
Police officers.
Police off. No, they got state plates now, but it does have an exempt. It's like exempt, right? There's lots of things that get exempt. Okay. So this principle, like we just spoke of, applies when with particular force to selective enforcement of code provisions against those asserting creator-endowed rights. When municipal corporations, state corporations, enforces victimless code provisions against wisedomians while ignoring similar conduct by others that they allow, the litigant can invoke the Roman Catholic Diocese to establish that such disparate treatment violates principles of equity before higher law. Do you see where I'm getting at?
Y'all.
You.
They can go F themselves.
Rules for thee, but
It's
not
not
for
about.
me.
It's not about they can go F themselves. That's not what we're about here.
It's,
We're about
no,
unity. We're about
it's
no. Hold on.
colloquial.
No, please, can you stop drawing on the screen? Like, how do I do this? Third time. It's not F themselves. It's we need to get the comprehension and knowledge back to the forefront. We need to have unity and understanding again. We need to have law enforcement really caring about our communities again. We need to have them helping rather than harming.
I love that.
I need more videos, bro, of cops doing good things. Can y'all start helping me find them on TikTok or I want to start promoting that. Like, I'm not going to be a bootlicker, but I definitely want to see where good things are being done. I need more of that.
Is that even happening out there?
I'm seeing a couple every now and then, but I would like to see more.
I know
We
some
start hyping
very
that up,
good.
maybe we
I
can.
know some good ones, really good ones.
No, you don't.
I've actually come
Can't-
across a few myself. My husband and I.
So what I'm really trying to do is I'm trying to get it to the aspect of to where if we start bringing forth positivity, right? What ends up happening is that more people might see that, but yet they know that we're litigating against them anyways. And it's like you're almost speaking it into existence. You see what happens? Speaking it into existence, we can build unity. We can build power. We can build compassion. We can build integrity. Tell me how I can help your department do better. Tell me how we can help the image be dispelled. Tell me. Oh, the image can be dispelled by training your people better, by having more compassion, by doing better for the community. That's what I'm about, man. That's what I want to see, okay? Like, I want to bring that forth, but I ain't got the eligibility to do so. Nobody's, like, they ain't giving me the eligibility to do so. I'm only seeing bad all the damn time, 24/7, bro. I'm tired of it. So, you know, it's just gotten to a point where, at least on module 1, hopefully y'all are understanding this one. We're not getting into drafts and deeper aspects yet on how to apply them and how they're structured. That's going to come in later modules. But what I wanted to do is have y'all look at the ontological aspects of looking at the differences between, again, the conventional aspect of things, how it's traditionally done, and then coming in more on that natural rights aspect. Again, everything is irreparable harm. Everything. You have to recognize that. Now that you recognize it, how are we going to articulate it? How are we going to bring it forth? If you can recognize the differences of irreparable harm, you can understand when it's time to just go ahead and hit for an interlocutory appeal. Do you get my drift? Why are we playing with the lower courts? Do you get my drift? You may not like it at first. They may deny you on the lower one. They may deny you on the higher one. But when you take it up to the next one, if you again are articulating what is happening and you can show irreparable harm, then what's going on, especially when there's no corpus delicti? What you mean? Where are we going? I could get in deeper on this one, but what I'm going to do is I'm actually going to provide y'all this document. And this, I think, is, let me see, is this just for, I got to make sure it's for just for module 1, because if it's for more than module 1, I can't give it to y'all. Oh, no, it's just for module 1. Okay, cool. Cool, so that's probably going to be all that I got for module 1 on the interlocutory appeals. What y'all think? Chilling? Y'all like that or what?
Absolutely fantastic.
Ooh, okay.
Great. That segues into my case.
It does, yes, for sure.
I found out today on some deeper research. I'll just give you guys a little bit of background on my case. I was driving through Nisqually Indian tribe reservation and got pulled over and was given a ticket for driving without a license. And because I didn't have state issued ID, he decided he was going to take me to jail. So he did, and I beat the case on jurisdictional challenge, and they dismissed it on a what they called a motion. But anyway, they dismissed the case, and so now today I filed a suit, and but that was after Cam gave me some real good information through Manus that I couldn't sue the cops and I couldn't sue the tribe, but I could sue the tribal police department. And with what you just said, Cam, they gave me some relief because by suing the police department, it's forcing them to educate their police officers. I wanted to sue the police because they violated my rights. But then when I found out that I could only sue the police department, I was like, great, that's perfect.
What's that all about? You're supposed to hit the man did the thing. He's responsible.
Nah. We'll go into it real quick, Ty. Get a little bit more detail. What's going on?
There's tribal sovereignty stuff that you can get.
The old tribal sovereignty, boy. They get free reign. I'm talking about they get free reign. It's pretty wild. The law.
Nation or a whole nation.
Yeah, when I first read it, I was about to give up, but Cameron says, "Don't give up. There's always a remedy." So I got clear on the remedy because there was a couple of things that weren't clear, and I didn't know who I was going to sue. So I asked Manus, I don't know who to sue. Who am I suing in this case? And so they came back with this dissertation and made it real clear that I was suing the police, the tribal police department.
Which one was that one? Which document was that where it broke it down? Comprehensive filing guide? This last one?
I did a query myself.
Okay. And what about detailed analysis phase 1 and 2 litigation?
Yeah. I don't remember which document it was in, but I had to go to the tribal rules, and I found it in there also that substantiated it.
Look at this, y'all. Look at the facts on this bad boy. Oh wait, y'all, I don't think y'all can see my screen yet. Watch. Oh, look at this shit. This shit is wild, my guys. The Nisqually tribe can claim immunity from most lawsuits. Well, damn. Well, damn. You got to go through 3 different court systems. You got to navigate through 3 different court systems. Pre-filing, you got to go through the whole city. We did a lot of work on trying to figure out what you got to do to get remedy and the best aspect too as well. There's a lot of work we had to do to get it, but then we got a conference and filing guide. So what all did you do so far, Ty? You just did a internal right now with the notice over to the city or what? Or to the tribe?
Yeah, I sent the notice of claim to the
Notice of
tribe.
claim? Yeah, there it goes. Yeah.
Yeah, to the tribe secretary.
Yep.
Yeah, right there, top
Yeah,
one.
this is the checklist. Yeah, this is the checklist. Okay, cool. Yeah.
And this wasn't actually correct. I found a little bit of discrepancy. But
Okay.
I had to file with the secretary, the police department, and the tribe attorney, but
Okay.
not to the police officers that were involved.
Okay,
That was optional.
Now wait a second. Remember, we went through the cross deputization of them. Remember? So you need to still check to see if they've been cross deputized due to the fact that they took you to Thurston County Jail. Remember? That was one of those. See right here, yeah. Check to see if the cross deputization agreement. They're telling you that you can't bring in the officers, but you can. Remember, we went through that cross deputization agreement, and if they had that while taking you to Thurston, they still could.
Yeah, so I have to put in a request for that information.
Yeah. You need to check into that because they can't. See, I think they're telling you that they can't be. Someone's telling you somewhere that they can't be. I don't know if it's a system or not, but we went in. See, we had that developed early on. We was coming on early with some things, and then we came back and was like, oh, the checklist, and then we broke it down even more. We got the notice of claim and all that. Oh, it was like our last meeting. Yeah. And then we got through that checklist. And then that's when we got deeper and found that the cross deputization agreement documentation does allow you to pursue them due to the fact that they took you to Thurston in the first place.
Yeah, but I think that would be in filing with the state where I would go after the police themselves.
Okay, possibly then.
I don't know for sure, but that's what it felt like.
Again, all these each tribe's different.
Yeah.
Yeah, for sure, for sure. Then step 2. Okay, so essentially keep going then.
Keep going where? That's what I did. I filed that today. I got to go back to and now see, okay, now what do I have to do now?
Right. So with his, because he's within the tribal aspect of things and having to combat the tribal aspect of things, it just makes it way more difficult because of the immunity. But there still has to be there has to be relief due to the wrongs that were done. That's just part of natural law. So we'll figure out some remedy. We got to go through the tribe first, and yeah, we'll have to see where it goes. But there's a lot of research on Todd's shit. Hopefully you've been reading everything because there's a lot to it. But step by step. Yeah, step by step. I saw you working on it today. What else we got going on out there in the crazy land? I hear that there's some issues with Trump. Where's all my Trump supporters? What happened? They're not shouting Trump no more.
I'm still shouting a little bit of Trump.
I'll
shout on Trump all damn day, man.
I just don't really care about either Democrats or Republicans at all.
I forgot all about it. It's kind of getting hyped to where it finally made it to my ears though, because they're talking about Epstein and stuff. So it's kind of made it to my ears.
It's a good thing, Cam. The whatever the democracy part of the thing that's happening, that's all going on. At least it's sort of working in a way because all the people, they're not blindly following their leader like they did when Biden was in place, and you just couldn't question anything. He's not fucked up,
Now the reason I use Manus,
but they're questioning the crap out of him, so it's good.
Yeah, Mr. Reed, the reason I use Manus comparable to ChatGPT is ChatGPT, they demolished the law aspects on ChatGPT. We all watched it when they went from the model of 01 to 03. They intentionally let everybody know in their premiere of that model as well that they intended to downplay the law aspect of what was transpiring with our nation, coming through and doing all the research. I'm sure there was a large amount of people in this law sector, and they demolished it. And not agentic. Well, ChatGPT has somewhat of some agents that they just introduced, but apparently I still haven't used it. Apparently from some researchers that I highly depend on opinions from, that I read or listen to that 2 times, just to get a quick update down then, is that it's trash. So there's no point for me to use it because Manus' agentic work and continues to get better and better with each day. And literally you have 90 agents or 90 LLMs working at your project at once, going out, scouring the internet and doing whatever you want. I mean, you could literally have Manus log into your Instagram and manage your whole Instagram account if you wanted to, all day.
No shit.
Straight up, bro. Like anything you want.
Well, that's how you made the website, right?
Yeah, that's how I made the website. Yeah, but nobody knows about the website yet. That's
Awesome. Thank you, Cam, for that clarification.
But it does matter.
Wisedome top secret.
Yeah, it's Wisedome top secret. But I will say,
They can't hear me.
Hold on. I can hear you. Yes, and what I will say is your prompts are what matters, bro. That is one of the most important things. If you don't have a good prompt, your whole response is going to be generic. It's going to be really bad. And so in the Discord, I'll drop some more prompts, some good prompts for y'all to tinker around with. I got some pretty extensive ones, bro, and they work very well. And most of the time now, I'm using 2 sets of prompts. I'm using a prompt for the front end work with an expansion, and then a second prompt for all the back end work on the guide. And just a comprehension understanding of how we need to develop things so people can learn. Because again, I'm not an attorney, right? I can't teach. I can only give you the information. I can only show you the information. Just like Troy showed me information today that's totally killing the case for Salem. And there's no reason for them to pursue. And if they do, it's prosecutorial misconduct. I mean, it's literally, we got to start finding these fine-tuned things. And
Cam, can I ask a question? Is it when you say a prompt can be a whole long several paragraphs of like looking for this, but definitely not this, but definitely some of this, and it's a lot of instruction. That is what a prompt is, right?
Yeah, you see this prompt right here?
Let me get a good closer look at it here. I gotta turn my camera off.
Started on the top up here.
Yep.
See how this keeps going and going and going and going and going and going. This is a prompt. This is one of my prompts.
Wow.
Yeah. Like I'm not playing, bro.
Motherfucker, don't go so fast. Dude, stop at like two.
Cam,
Stop at least
No,
one of them.
I'll give it to y'all if you want.
Cam,
No, I'm just saying like
I'll give you the prompt. Go
statutory
ahead.
currency. So you're dealing with everything. I was just read one of the lines about statutory currency. So you're just throwing everything in there.
Well, I gotta
As you learn it, you
get it
put
how
it
I
in.
want. Yeah, you gotta get it how you want, bro.
As you learn it, you put it in. So and there's no limit. I get it.
Nobody
Hey,
makes
Cam.
documents than Cameron. Nobody.
Chill, yo.
Hey, Cameron.
What's up, G?
So you could actually like prompt Manus with an entire freaking book.
Yeah, for sure, no doubt.
Freaking, that's awesome. So where did you learn this prompting thing?
Been
Figured it out.
using ChatGPT or AI for like almost 4 years now. In October will be 4 years.
Oh, no shit.
Yeah, I've been using AI that long, bro, for real. And
Wow, man.
I got proof on that just due to the fact that my translations from the French books that I was doing, almost 3 years ago now on my history stuff. Nobody had translated Brasil de Bourg, the 4 letters to Mexico, that was going over to King Philip, talking about all the secrets of what they found out of America. Nobody cared to translate one of the most important documents that's ever been written in relation.
Dude, that's fascinating.
It's insane to me.
Oh,
Literally
That's
tells
fascinating.
everything, bro. I'm not even gonna do it right now. I'm done. I'm not gonna talk about history right now.
Hey, we could do that some other time, man. But I mean, so is there any specific courses that someone can go out and like sit down like a textbook type of thing and learn how to do the prompting, or you just have to do it
organically.
experimentally?
You can actually find I recall I did the workshop 7 a
Stop.
while back.
I'll just do one. Don't push him off to somewhere
There you
else.
go.
If you got the guy right here that can do it. If you're asking,
Exactly. Cam's the guy to go.
Download that document that Cameron just dropped in there and
Cam,
study
how
it.
much of the
Right
prompt
there.
is just
Let's
common
do it on
sense?
Saturday.
Say that again.
How much of the prompt is just like common sense, like your experience? It's like, no, bitch needs to know this.
There's a method. There's a method, and see, all of y'all are gonna have me teaching the method, but don't go teaching everybody else. I'm gonna give you all the secret sauce, and I don't mind. That's the whole point of all this. We started to do this secret sauce a while back ago. I think I did some prompting and teaching how to maneuver somewhere in the Discord. But the other aspect, of it too is that you have to become the other person. You have to at least know enough to become the other person to be able to help them in any manner that you have to become them. If you don't fully know what's going on with their situation, if they have not fully wrote out into a transcript of some form, an affidavit, of what truly happened, how is anybody going to truly, be them to help them in any essence? And again, you have to get the like what you'll notice in the prompt, if you click that one, if I'm not mistaken, creator-endowed rights is pretty significant throughout that bad boy. Maybe not. Maybe this one. No, this one isn't. This one is not my creator-endowed rights one. Yeah, because that's my guide, and then right below is my creator-endowed rights. So I got like prompts for like family law. I've got prompts for philosophical creator-endowed rights. That's one. Civil legal prompts, quasi-criminal prompts, international trust edition prompts, taxation edition, and then hypothetical script formulations as well. So it's like I'm developing prompts based on performances that I'm seeing as I've gone through time to say, okay, I really like this thread. I really like what's being brought forth and everything that I've created from it and its perspective currently in its situational place. Go ahead and create a prompt based on everything that you've brought forth for any other further inquiries or threads that I might possibly make. And once you've already, let's say you've got a thread that's working like you like it, well, tell it right now, create me a prompt that I can utilize with another platform that is very highly detailed, that with all, you know what I'm saying? So you operate just like you are right now on my next, you see what I'm saying?
Mm-hmm.
You can do that too. But no, I don't mind doing something. It ain't going out to the masses. It'll have to be an exclusive wisedome only. I'm not throwing that out there, so.
Yeah.
You can even take the website link and just put it in there and ask it a simple question about that. and it'll give you a lot of information about that.
Well, we got one that I'm trying to do that to where, because I know a lot of people still ain't up on par with like AI and stuff. It's still kind of lagging. A lot of people are coming in, but it's still kind of. We mentioned the Westlaw, bro. And they're supposed to be giving me a free week here soon, Chris. So, but where was I at? Oh, I developed a website through Manus. If y'all just want to see real quick, I'll actually let y'all see a sneak peek. Where did I put that in the Discord? This in Wiseman. Where is that at? This one.
While you're looking for that, can I ask you a question?
Well, it's already right here. I got it. So, I'm gonna put this in the chat. Y'all can take a peek if it works. If it messes up on you, just refresh. But what I'm trying to do is I'm trying to see if people will just, if they don't want to have to deal with me per se, and they don't want to have to do an interview, and they don't want to have to be a wisedome member. I don't want to be a part of that. And I don't want to sit here and try and learn all of it either. Okay. If you want something that you take no responsibility, don't throw no responsibility on me, and you want something custom tailored for you, go to this website, boom, you get the trifecta. Go ahead and get you the trifecta. Go ahead and get you the affidavit. Go ahead and get you that memorandum in support of memorandum as unconstitutionally applied, and then go ahead and get you that bill of particulars, because the DAs hate the bill of particulars or motion for more definite statements. Right? They don't like them. So, things like that might pop off, if you promote your own thing, to do your own thing on something like this. You see what I'm saying? Now, this was all created through Manus, this whole website. I told her what I wanted, and she went out and created the whole website. You promote this good enough with a domain and an Instagram, you might come out winning on top. You know what I'm saying? You got to think outside the box. There's so many ways to get out there and help people and, receive some donations for what you're trying to do out there. A lot of people
always think outside the box, because the box traps your spirit.
in my circle don't reach out to every circle. Y'all follow a lot of people I don't follow. Okay? I'm sure Ruben follows some Mexican guys, some vatos, and some, I'm sure he's definitely following. Troy's down there following the metal bands. He knows all the metal guys. So all my metal guys are getting covered. Okay? Okay, James, he's out there talking to fishermen, right?
Yeah, I do.
My boy Jesse, he down there in California talking to all the cockfighters and all the people that he associates with his business.
Yeah.
You see what I'm saying?
Crossing streams, what the heck?
We're all over.
Well,
So-
and then you have Wesley and I traveling the country, talking to people in truck stops and deliveries and pickups
And
everywhere we go.
Our truck drivers are the foundation of this nation,
How's it?
especially on sound principles.
How's it?
Damn right.
Yeah.
Amen.
They're
Did they
going
fix
away
your truck
though.
all right?
That's for
All
real.
automated. Truck drivers will be gone soon.
Yeah,
No, we
that's
won't.
that's a
They
guy.
ain't never getting rid of them.
No.
They'll
They'll
get
try,
they'll-
but they ain't going to be able to.
They'll get
You
rid
can't
of them.
you
They're
can't
gonna automate
litigate
them.
against a
Battery
robot.
only goes so far.
But
You
what will
can't
happen?
litigate against a robot.
I'm telling you, what's going to end up happening, bro, is they're going to bring through the automation like crazy. Then they're going to bring. You're already seeing what's happening. What's happening is we're going back to the gold standard. What just happened about 3 weeks ago in Texas, y'all?
They introduced a bill.
And what bill did they introduce, and what was it about?
Using gold as tender.
Going
legal
back
tender.
to the gold
Same
standard.
with Florida. Florida did that too.
It's
You
happening.
can spend gold and silver in Florida.
What's happening? You can see.
And that's
If
nice.
you ain't buying gold right now, you tripping, because that shit about to skyrocket, especially with all the money they just printed. It's inflation, baby.
Silver.
Yeah.
It's inflation.
Silver and gold, guys.
Time we right here. So I've been outside of the financial markets paying attention to that since I started this. I used to pay attention to more of the housing markets and the interest rates of the financial sectors, and what's just going on with the inflation aspects. I used to be more in tune with that, but I've just been too busy to keep up. But you can still see the signs. So pay attention to that. It's happening. And we're about to go into a digital payment system, whether it's cryptocurrencies, little minor cryptocurrencies, and real tangible goods, or monetary money, which is gold and silver. So gems, minerals rather than fiat. That's just where it's headed.
So what the prompt? Is a prompt a body of work? on a certain subject?
It is.
I just want to get an understanding.
Yeah, that's what he
List of
said.
commands.
Yeah, you're setting up the parameters on how you want your operator or AI to work for you. What perspective and persona they need to encapsulate to operate
Oh, so it has to do with
and desire. Yeah.
giving AI a foundation of you.
Of what you want, whether it's you
Right.
or what you want. Yeah, the perspective.
Well, yeah, and one thing you just said, you can take a whole book, like say, I don't know, a police policy from a certain city with their policies, drop that into Manus or
The only
your
aspect
AI.
is that the only aspect is currently now, right now, it will be better later. But currently, right now, what you have to do is you will actually, if you put in a whole book, you would actually have to at least advise her to set up a full analyze and research of the whole document. Because if not, what ends up happening is that because it's so big, it will skip certain parts and won't remember because it has no memory. It didn't fully read it. It's not real in that aspect. It's artificial. So if there are parameters of certain aspects within the book that you needed to find to encapsulate, I would do that rather than trying to depend on the whole book itself. You would have to be very particular. You would have to be very specific on what you're wanting from that book to be encapsulated and used within whatever aspect you're using it for. And I would only like to bring your attention to that because that's pretty, you gotta do it like that or you're gonna get mistakes for sure.
That's really
Right.
good
Chat-
advice. That's really good advice. Thank you, Cam.
There's just
I
too
use
much.
ChatGPT a lot.
Can't drop
It's
self-governing
got a
bra into it and then expect everything out of it that it's telling you. It won't do it for you like that.
You got to go piece by piece on certain aspects, or just focus on one specific thing at a time. And that's why I say it's very important for people to understand, like, when we be like, getting together on our consults and we're searching and we're researching and we're developing, right? And we're like, oh, what about this and that? And we build, let's say we finally utilize the technology to build us out something. And the people see it and they're like, oh, but what about this? It's like, wait, Papa, this is just our skeleton. We got to add on all the meat. We got to get the muscle going. Then you start going in each section and certain things you start building and bringing in, and then you get to a full, complete document. These systems aren't all the way bringing out something completed unless you're finally getting to the point where you've built out quite a good amount of information for it to encompass and know, for it to finally say, okay, well, we've developed so much that now we're in alignment. But even still, there's corrections. Like today, I was working with Miguel and did another creation on some Supreme Court work that we're doing. The Supreme Court is amazing to work with. Anytime you make a mistake, they let you know about it and give you an opportunity to correct it. They're so nice. I love them. And yeah,
You finally found an adult.
for real. Well, we need to be there all the time. We literally just need to start bringing up constitutional aspects from the very beginning and move it up, right? Bring in the judicial notice, come in on our special,
Amen.
let everything be known. Say, are you going to honor your duty to have this dismissed based on the constitutional violations? Let me know now, or I'm just taking it up.
Hey, Cam.
Or nothing more.
Nothing to talk about.
Hey,
What's up, Jess?
So on my case, my next step is to take it into the federal court.
Yep, United States District Court on the federal level. Y'all check out my boy talking right now, Jesse. He sent me these glasses.
Those
Y'all
are
like,
cool, man.
y'all like them?
Those are cool. I want some.
Yeah, I started my own brand. So
Hey, can we get them in prescription?
what you do, you take them to your eye doctor, and then they'll change out the lenses.
Ah,
Yeah,
you ought to get,
bro. Yeah,
you ought to get with
prescriptions
you ought to
put in
get with USAglasses.com, man. Get your frames on there, bro.
All right. Yes, sir.
Yo, thanks, Jesse, for the sunglasses, bro. I got a shirt I ain't wore yet either. It's pretty fresh. It's very nice.
Those
I was talking. I was
Yeah, I'm wondering when you're gonna wear that shirt.
Oh, man, I need another one before I do it. I
No,
can't.
you don't.
Yes, I do. I can't.
No, he's got. I know what he's gonna do.
keepsake,
He's gonna
bro.
put one. He's gonna put one on the wall in a frame.
I want it. Yeah, I want it in a frame.
Wasn't it
no
already
cap.
hanging? Wasn't it already hanging?
thinking that.
right over there.
Yeah, I started the other day.
Yeah, there you go. He got it over there like a trophy.
Yeah.
Yeah, man. We what? Put it on.
Man, you better jump
What?
on that bike and wear that
Uh,
shirt.
I will one of these days, but I need to get another one made for real. Y'all need to let me know. Okay, so that's the end of module 1. Free talk afterwards. We have an 8-week course, so there's going to be 7 more modules on this one. We're going to get deep on the interlocutory appeals. I just wanted to again make sure that y'all are understanding, comprehending the conventional aspect of how we're coming in, or how traditionally you would come in. It's always been being kind of taught is requesting versus the natural rights approach. We need to get that distinguished. Hopefully y'all are understanding the Catholic Diocese case versus New York, and the aspect there that irreparable harm is very serious. And instead of those 4 elements, they spoke of the aspect that we can bring in just any minimal constitutional violation. Doesn't matter how small, how large, or how long, that meets irreparable harm, and can be brought forth and be utilized. Again, we just got to bring it forth in the right manner.
Did you drop the Catholic Diocese in the chat here?
I
Or is
did
that part of
drop.
something else?
If you scroll up, you should see it. It's a PDF from me, and it says Module 1 Detailed Case Studies at 8:28 p.m.
Hey, Cam.
Chat. Hold on, everybody. I need y'all to say goodbye to YouTube. That's all y'all.
Bye, YouTube.
Peace out.
YouTube.
Peace out,
Bye.
YouTube.
Later.
Bye.
This one don't go on YouTube, I don't think.
YouTube, if you haven't gotten part of us, you best come get part of us.
This one don't go on YouTube. This one don't go on YouTube.
Oh, yeah.
Oh, it ain't?
Not this one.
It's going in the
So we
archive.
greeted and said goodbye for nothing.
Yeah.
Well, I don't know. Maybe I guess this one. Guess what? YouTube. This is actually a wisedome exclusive. If you want the rest of the episodes, this was your teaser.
There you
Bye.
go.
There you go.
Yeah. Oh, that's a good one.